Well, my friends, Mondays are gonna Monday you sometimes. We got this show started and 30 seconds in, a restream dumped it. But we're back. Happy Monday to you. Apologies for the delay. Welcome to TCF Live. My name is Dan Soul. Now that we're finally started, I will guide you on a 3-hour journey through Courtlandia, starting in Michigan with Judge Anzalone. And oh, by the way, Tim, thank you already for the $2. I appreciate it.
In the matter of file number 2011-37387DM, this is in the matter of Eric Watson versus Jamie Watson. This has been adjourned to August 24 at 8:15 in the morning. All right, Ms. Watson?
Yes.
Your case has been adjourned to August 24 at 8:15.
Okay.
Okay, thank you.
August 24th at 8:15.
Yes, ma'am.
Okay, thank you.
Thank you.
Uh-huh.
In file number 2014-40006, DP, in the matter of Jordan Gerald versus Tristan Pizana. That matter has been adjourned to August 24 at 8:15 in the morning. In the matter of Andrea Hawker, file number 2014-40451DS, Andrea Hawken versus Eric Zay. That matter has been adjourned to August 24 at 8:15 in the morning. In the matter of file number 2014-40457UE, Tara Daniel versus Jamar Bani. That's been adjourned to August 17 at 8:15 in the morning. In the matter of file number 2018-45528DM, Jessica Smith versus John Vetter. That matter's been dismissed. In file number 2018-45884DP, April Martin versus Jonathan Emmett. That's been adjourned to August 24 at 8:15 in the morning. This person. Mr. Damon, thank you.
Yes,
in the
ma'am.
matter of file number 21-49014DC, Jersey Garza versus Armando Damon. Sir, that's been dismissed. Thank you.
Thank you. I appreciate you.
Okay. In file number 2022-49163DS, Patrick Ryan versus Shannon Bollinger. That matter has been adjourned to August 31 at 8:15 in the morning. In the matter of 2022-49901DS, Eric Zay versus Brandy Valdez. That matter has been adjourned to August 24 at 8:15 in the morning. In the matter of file number 2023-50368DM, Megan Ruger versus Anthony Ruger. That matter has been adjourned to August 24 at 8:30 in the morning. Sarah Holtz here? No. All right, Mr. Holtz, can you hear me?
Yes, ma'am.
All right, this is file number 2000. We have two files. We have two files. We have 2008-33341DM in the matter of Sarah Holtz versus Timothy Holtz. Mr. Holtz, on that file, it is arrearages only. You have a balance at this time of $4,888.21. Since April of this year, it's gone down about $100 or a little less. This is your third show cause. You've had one payment. That payment was $100 on June 3rd of 2026. And we've had no other payments. And then we have file number 2024-51596DM. That matter, the balance at the original show cause in April was $4,028. Now it's $3,521. And we had a payment of $1,055 on June 3rd and no payment since. So Mr. Holtz, I mean, at this point, we're in arrearages only. And you need to be making monthly payments. We're at the end of July. I need a payment today. So how are you going to make a payment today or tomorrow?
I talked to Jake on Friday and he said I could pay it online, which I did. It just is probably after, because I didn't talk to him till late afternoon. Probably after he went home.
How much did you pay? How much did you pay?
I paid 100 on Sarah's and 200 total for the Whitney's, which is what me and Jake talked about on Friday.
Well, what Jake wants is $200 a month on each case.
Okay. I can do that from here on out. On Friday, he said 100 a month is what he told me on Friday, but if you wanted, I can do 200.
Okay. So Mr. Holtz, I'm going to set this out to August 24. So you're going to pay the other 100, I think you said on Sarah's case, to bring that up to 200. And then I want an August payment on both of these before we come back on August 24. And don't make them on the Friday before because it doesn't show up in our system yet. Okay.
Okay.
So I would like the payment within the first 2 weeks of the month. All right.
Okay. Okay.
All right. So August 24 at 8:15 in the morning on both of these files. Thank you, Mr. Holtz.
Thank you.
In the matter of file number 2010-35128DP, Kayla Morris versus Scott Stevens. Anybody? All right, I have somebody called in on a phone. What's your name, please?
Hi, Courtney Miller. I apologize. I am a little bit late.
Oh, you're fine. Oh, let me find you. So, Courtney, what are you calling in for?
So I got something in the mail stating that I should be calling in for a hearing today as the plaintiff. It says July 27th at 8:15, and I called last week because the paper they had sent me didn't have the date on it, and I had spoken to somebody, so they gave me the time.
Ma'am, hold on. I need you 1 second. So, okay, Ms. Senkowitz, or Ms. Heron, I have both parties here on file number 2014-408. Is that 79?
Yes, Judge.
79DS.
I'm sorry, Your Honor. What was the case number again? I missed the last part of it.
40879.
Is that on the Hamblin case, Your Honor?
Nope, it's Courtney Walton versus Dakota Wood, 2000.
I'm sorry.
14 40879 DS. Courtney
He
Walton.
he has become employed and is making payments. That was canceled by the system because he has an active income withholding.
Okay. All right. So, Mr. Hold on. Evidently you have a job.
Yeah, I didn't know that my payment.
Hold on. And, so it's been dismissed.
Okay,
Oh, hold on. If you're gonna talk to me, you gotta come up here. I don't have a docket for you, so come on up.
Yeah.
So Miss Walton and Mr. Wood, it looks like the system dismissed it because you are now employed.
Yeah, I have a job with observable space here in town manufacturing.
Right, so they're gonna be taking income withholding out.
And payments that I continue to make though, if I wanted to make extra payments, will they be canceled like that? Because I got the letter.
Oh, you are more than welcome.
Right, I didn't know that it was.
Listen to me.
Sorry.
To make as many payments as you want and catch up your arrears.
Right.
You can do that online or you can pay here in cash.
Okay, I did it online, but I didn't receive anything about it being canceled. That's news to me.
Okay, and I don't know if the caseworker canceled it, they are required to call you the Friday before. That's Judge Olsaver and I's policy, but if the system did it automatically,
Okay.
they wouldn't have known.
Okay.
Okay?
Yeah.
All right, so thank you both.
Thank you.
Thank you.
Thank you.
That's Judge Olsaver and I's policy. Good English to start a Monday. Oh, Judge. That's okay. Mondays happen. Good morning once again, everybody. It's TCF Live. As we know, it's been a Monday here already. Barbara, thank you for the $5. Happy Monday, everybody. I missed all of you on Friday. Hope we have a great court day. I hope so, too, and we missed you, too, Barbara. I hope you're feeling better. Let's stay in Michigan. Let's go to Magistrate Urich. Say good morning there.
04144 and 144A. These are people versus Henry Mitchell Swope.
Yes, sir.
You, sir?
Yep.
Thank you. Mr. Swope, today's the date and time set for your informal hearing. An informal hearing is civil in nature. It is not criminal. No one's going to jail today on their traffic ticket, but it is considered serious enough that Sergeant DeSano issued the citation on the date in question, which was June 12 this year at 20 past 11. In the morning, you were operating a 2014 Ford, black in color, on eastbound 13 Mile Road and near Garden in the city of Royal Oak. And at that place and time, you were cited for driving without due care and caution. And you were also issued a citation for violating your graduated license permit. The sergeant's remarks showing on your ticket indicate eastbound 13 shut down due to accident, police fire with lights activated, cone pattern set up, drove around into oncoming traffic, and apparently it was getting closer to midnight and there was a passenger under 21 in the vehicle. So those are the two citations before the court. You do have three options through which to protect your rights. You may, if you wish, simply admit responsibility. The court will attach fines between 0 and the maximums, and that will close your case. You may also, if you wish, admit responsibility with an explanation that you believe mitigates your circumstances. Your third option is to deny responsibility. Absolutely, your right and your privilege if you do so. The court will conduct your trial forthwith. Both parties are sworn. The officer testifies first. It's his burden of proof. Then it is your turn to testify. Then the court makes the finding of responsible or not responsible. But please recall, since we're in civil court, the burden on Sergeant DeSano this morning is what they refer to as a mere preponderance of the evidence, which is a rather modest burden when compared against the heavy burden of guilt beyond a reasonable doubt, which is reserved for criminal matters. You're not charged with a crime. These are civil infractions. So as to violation of graduated license and failing to drive with due care and caution, do you wish to admit and explain, or deny responsibility?
You're just going to.
Yeah, just admit.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak with a violation of your graduated license rules, and as well, you failed to drive with due care and caution, correct?
Yes, sir.
Your Honor, I'm sorry, Your Honor. May I ask a question?
you're Mr.
I'm
Swope's
the father, yes. I
father?
am.
Okay. Historically, you're not an attorney, but given the fact that he's already young enough to be in the graduated license scheme, what's on your mind, Dad?
Well, I think we were trying to give Henry some advice and counsel after this ticket, and it was unclear to me exactly the scenario because there was construction and there was lights going with emergency vehicles.
Okay. If
the
Henry has any doubt about his culpability, now would be the time to contest the ticket. So it sounds to me like you're actually advocating on his behalf and suggesting, I'm not even sure what, that maybe he's less culpable, which is fine, but we can place this into a contested context without any problem, if that's what you wish to do.
Just to hear what the proper course of action would be under those circumstances, because I was unable to understand fully the situation to give him the proper judgment.
All right. And you weren't there, so the court gets that. The court always defers to the citing officer under these circumstances, regardless, Sergeant Asano.
Do you want me to just explain the situation of what happened since he already admitted guilt?
Could you simply reiterate what it is that you witnessed briefly?
Yes, sir. So eastbound 13 Mile, at that time, the curb lane, so lane 1, the right lane, when driving eastbound, was technically under construction, so the left lane was open. At the time of this incident, I had positioned my patrol vehicle north and south, so blocking both lanes of eastbound 13 Mile. A fire truck had also blocked it, tow truck, and an ambulance due to a head-on collision at Garden. I had thought, since those were plenty of obstacles to see, but I also wanted, since I had to go back and forth between the accident scene and where I had the road shut down, I decided to take some of those construction cones, which I don't even know why they were out there. Nothing was being worked on at the time. I think they were preparing to shut down the road. I used some of those cones to also divert traffic into a parking lot in front of my patrol car.
Okay.
I had moved some of those into the left lane. So I also had those on top of multiple emergency vehicles out there to show that traffic had to go around us into a parking lot and then pop out on the other side of us.
All right. I think that is helpful and illuminates our circumstances. Based upon that and based upon the rest of your investigation and the traffic stop, et cetera, did you have anything you wanted to add related to Mr. Swope's circumstances?
I will dismiss the violation of graduated license. He was on his way home. Yes, he did have a passenger in the vehicle with him that was not of age or should not have been in the vehicle with him. I do believe that he just made a genuine mistake. He was on his way home. I believe that he was almost home. And so I will dismiss the violation of the graduated license permit.
All right, that one is dismissed. And with respect to the due care and caution, gentlemen, the fine is $150. That is payable through the pay portal on the court's website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That is due within 14 days. Mr. Swope, you're a young fella. You're going to be driving for probably at least another 55 or 65 years. Okay. So let's make this the one and done. Okay.
Yes, sir.
Good luck to you.
Thank you.
Thank you.
And case number 26 RO 03722. This is People versus Joseph Benjamin McQuarrie. Matter was set for 9 o'clock. It is now nearly 20 past. Mr. McQuarrie has not checked in with the court, so the court is prepared to mark this matter as a fail to appear default. And with that, I think your flight of motorists is over.
Thank you, sir.
Take care.
Have a good night.
Alrighty, friends, good morning once again. It is TCF Live on a glorious Monday, where apparently the feed is automatically going to our bear friends. I didn't have that planned, but that's okay. Lots of bears out there this morning. Check it out. 1, 2, 3, 4, 5, 6. I'm counting 7. That's a lot of bears. Well, we can stare at them for a second. Well, I get the next thing racked up. All right, let's do this. Let's go to Ohio. It's been a while since we've seen this guy, Judge Colada.
State of Ohio versus Christina Johnson, case number 26 CR 500. The defendant is present with counsel John Patica. We're here today for a sentencing hearing. We were last before you on June 30th of this year, where the defendant was found guilty by jury to count 1, being trespass and habitation when a person is present or likely to be present, a felony of the 4th degree. At the conclusion of that trial, a pre-sentence report and psychological evaluation were ordered. The defendant has 112 days of jail time credit. Thank you.
Mr. Fatika, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, good morning. I've had an opportunity to review the PSR as well. I've struggled with what to present to the court this morning because I'm at odds with Ms. Johnson as to what outcome we should request. I respectfully suggest to the court that she does need help based on the facts of the case. I think it's also supported by the fact that she has no criminal history up to the age of 36 and that she's got 6 cases in the last 4 years, no prior felonies. She has a pending ILC in Portage County. I'd like the court to consider the fact that in 112 days at the Lake County Jail, she has no incidents of any kind, which I think is somewhat rare at this point. You know, not late for 1 count. No extra linen, nothing like that, so she can't follow rules. But I think part of her overall situation is that she's denying she needs help, and that's digging the hole further. I would just ask you to consider those factors in fashioning a sentence here.
Thank you. Ms. Johnson, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
No, thank you.
Mr. Fatika, anything else?
No, thank you, Your Honor.
Ms. Bell for the State of Ohio.
Thank you, Your Honor. The state is recommending prison in this case. It's very clear that Ms. Johnson would not be probationable. She refused to participate in her pre-sentence interview and the psychological evaluation, not to mention that she was in the process of doing intervention and failed to appear in Portage County. So the state does not believe that she's probationable and would be asking for prison. Thank you.
This court has reviewed I haven't reviewed a pre-sentence report. I ordered a pre-sentence report and investigation. However, the defendant refused to cooperate with the probation department, so a complete PSR has not been completed. I have been provided a criminal history of the defendant, and I've read and considered that. I've considered what Mr. Fatika's had to say here today, the prosecutor's recommendation. The defendant was afforded an opportunity to address the court. She chose not to make a statement, which is fine. I've considered the facts and circumstances of the offense involved. Obviously, I presided over the trial, had the chance to hear all the specific facts. I've considered that, the nature of the offense. All this is considered on the purposes and principles of felony sentencing set forth in 29-2911. For the factors in 29-12, nothing stands out factually indicating the conduct is more or less serious. I guess I will know in terms of the facts themselves. Normally, there clearly was a trespass here, but normally it's more of a trespass than what we have in with this charge and what the facts were in this case. I guess in that regard, factually, it's not as serious as the other normal offenses for this. Recidivism factors, defendant was on an intervention plan with the Portage County Common Police Court after pleading guilty to the exact same charge in Portage County, where she did the same thing. Well, though those facts are much more serious than the facts in this case. Though she denies she did that, from what I understand. But she was on an intervention plan with Portage County and Judge Pittman at the time she committed this offense. There was a warrant out for her because she had violated the conditions of that intervention plan. That warrant was pending at the time she committed this offense. She does have prior criminal history. Aside from that prior trespass case in Portage County, there are theft charge, a disorderly and unauthorized use of property, and another disorderly conduct, I believe. All of this not starting until about 3 years ago. 21. What's that? 5 years ago now. Defendant has failed in the past to comply with previously imposed sanctions ordered by courts. She's actually been on intervention in lieu of conviction twice and has violated both of those times that she's been on that. No genuine remorse, and there's no remorse, let alone genuine remorse. She denies that she did it, which is fine. She can maintain her innocence. But she has denied doing anything in her history that she's ever been convicted of or charged with. She failed to cooperate with the probation department. No factors indicate recidivism. Well, I should say that. She did lead a law-abiding life for a significant number of years, again, up until 2021. There's no criminal history. She is 40 years old, so up until the age of 35, no history. I'm not sure what happened. It appears there could be some drug issues because she was at a sober house, is what she had said. Maybe been some issues there, but again, I don't know for certain because she refused to cooperate. Again, I don't have a complete pre-sentence report, so I'm not even permitted to consider probation as an option. Prison is consistent with the purposes and principles of sentencing. There's no way I can find the defendant's amenable. She doesn't want to be on probation. She didn't think she did anything wrong. She doesn't deserve to be on probation. I'm not going to put her on probation. Therefore, it will be the sentence of this court that the defendant serve a term in prison of 9 months. She has credit for 121 days she's already served. Need to advise you upon your release, you could be placed on post.
It's 112, right? Pardon me.
112.
I just want to make
Push
it
the
clear.
numbers. Thank you. 112 days of credit. I need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can send you back to prison as punishment for violating their rules for another, in this case, 4.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. And it's ordered to pay all costs incurred in this action. Further need to advise you, Ms. Johnson, that you do have a right to appeal the conviction in this case. Specifically, if you're unable to pay for the cost of an appeal, you have the right to appeal without payment. If you're unable to obtain an attorney for an appeal, an attorney will be appointed for you without cost. If you're unable to pay the cost of documents necessary for an appeal, which includes a transcript of the entire trial, and anytime we are in court here, the documents and transcripts will be provided for you without cost, and you have the right to have a notice of appeal timely filed on your behalf. I think that covers everything. Ms. Bell, is there anything else for the record?
Nothing further, Your Honor. Thank you.
Katika.
Your Honor, we'd ask for a stay of execution of sentence or an appeal ban.
That's denied.
And then just for bookkeeping, do you want me to keep track of this? Do you need to file a motion to withdraw and ask for appellate counsel to be appointed?
Is that what you want? You want to have a different attorney appointed?
Please. What I've done in the past is just make a note, make sure that.
Yeah, I was just about to tell you to do that, just to make sure her right to have the notice of appeal is protected, but we'll get someone appointed then.
Thank you, Your Honor.
And then put in the entry that the defendant's request for a bond pending appeal is denied. Please. That's necessary for her to be able to take the next step.
Thank you, Your Honor.
All right, thank you.
Well, other than maybe keeping something off of her record in the long run, the slow wheels of justice will turn. Any appeal that she might try to file will barely even get started by the time she is out of jail, because she was just sentenced to less than a year. So, anywho, good morning once again, everybody. TCF Live on a Monday. It's good to have you all here. I believe we're on episode 341 today. Let's go down to Florida. Wade Mercer.
Good morning.
Mr. Smith, good morning. Mr. Smith, you're here because you've been charged with one count of driving under the influence. Mr. Smith, your mother is in the courtroom this morning. Mr. Smith, I'm going to appoint the public defender's office to represent you. The judge from the weekend has already found probable cause and set you a bond. So I'm going to ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Smith. At this point in time, he's going to plead no contest to the charges listed. You understand he'll be placed on probation for 11 months, 29 days, $1,078 in fines, 50 hours of community service, 24 AA classes or equivalent to whatever probation says for double the alcohol classes, DUI school, and a minimum driver's license suspension. And he has signed his plea waiver form, waiving his right to jury trial, and call witnesses that have resolved this case today.
Thank you. Mr. Mitchell.
This is agreeable with the state, Your Honor.
Those are the same conditions. I know that you had some input from the mother or somebody.
Yes.
But
yes.
those standard conditions are fine.
Those standard conditions are fine.
Mr. Smith, I forgot to tell you now, while you're on probation, the solid, most important part of probation is you cannot drink alcohol while you're on probation. So you need to deal with that issue you have.
Mr. Smith, this is Judge Mercer speaking. Sometimes it's hard to tell who's talking. That was Mr. McDaniel giving you a very good advice about not drinking, because if you get caught drinking, you're probably going to get a substantial jail sentence. You've got some criminal history that I saw, but it's older stuff, and you've got no DUIs. That's why I'm giving you a shot at probation. Mr. Smith, did you hear that plea agreement?
Yes, sir, I did.
Do you have any questions about that plea agreement?
No, sir.
Is that the plea you would like to enter?
Yes, Your Honor.
Mr. Smith, I'm going to accept your plea of no contest to the charge of driving under the influence and judge you guilty of that offense. Sentence you to 11 months and 29 days probation, and he's pleading that as charged.
Yes, Your Honor. I know he didn't, he did blow the one time and didn't get the second blow in. So I don't know how legal the, if the other ones had a misprint or something on the, I know it couldn't be used against him in a trial. Whether it can be used against him for sentencing, I'm not really quite sure.
I don't know if the question I have is having the two sample rule, I think is relevant for trial. I don't know if it's relevant for driver's license suspension, if they consider it 0.15 or above better. I don't know. Mr. Smith, you need to understand that your license very likely will be suspended. I'll recommend the minimum. They're probably going to suspend it. And you also need to understand they may have other conditions that are not part of this plea. But these are the conditions you heard are part of the probation sentence. Mr. Smith, did you hear all those terms?
Yes, sir.
And is that the plea you want to enter? I think I already asked you that. That's what you want to do, right?
Yes, Your Honor.
All right. So it's 7 months, 29 days probation, be the sentence, $1,078 court costs and fines, successfully complete substance abuse counseling. Now, the substance abuse counseling is because your breathalyzer was so high, it's twice per week until you complete up to 24 classes total. So it's because of the breathalyzer being so high, 50 hours of public service work. I do recommend the minimum driver's license suspension. It's possible to do less than 24 classes if you go to a different provider. That's the AA number that I gave you, 24 classes. You also, if you enroll in DUI school within 60 days, that very well may take care of several of those classes. Mr. Smith, you can try to get off early. It's hard for a DUI case because state law sets the fine so high, but try to get off early and get all this behind you. But every probation case, especially DUI, has a condition not to possess or consume alcohol. So you do have that condition. Mr. Smith, what's going to happen next is they're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse because that's where the probation office is at. Ma'am, are you going to be able to pick him up?
Yes, sir. I'll be here until then.
He'll be here. It's probably usually 30, 45 minutes. They'll have him here. Once you get here, Mr. Smith, the probation officer, Mr. Goodson or Mr. Ham, probably Mr. Goodson, will go over the release with you, the terms of probation, and then you'll be free to go. Mr. Smith, do you have any questions?
No, Your Honor.
Ma'am, do you have any questions?
The only thing I would ask is if it's possible that he would be able to eventually get a hardship license.
It's on the first DUI, it's potentially possible. Mr. Goodson with the probation office is really knowledgeable about driver's license rules in Florida. So when you go to the probation office, Mr. Goodson will tell him the process, what he's got to do. There's certain things he's got to do. Enrolling in DUI school is number one. And if he does that, it's possible to get a hardship license after a dead time. Okay. Any other questions? So, Mr. Goodson, does the breathalyzer affect the hardship license at all?
And he lives in Louisiana, so that might affect it also. So he lives in Louisiana and he don't even have a driver's license. He's got to get them back. So he's got to. What's that?
He's got a Florida driver's license number though, right?
It's the ID only. So ironically, in Florida, you have to see someone driving to charge them with driving license suspended, but you can charge them with DUI. But so
that's strange.
Yeah. So he doesn't have driver's license, but he always got to do is pay a ticket. He told me to get them back, but he hadn't had them in 10 years. But I told him he needed to go get them fixed and get them back. But they have to go to Louisiana if he lives in Louisiana.
Yeah. Now the arrest record I saw showed no prior DUIs. You've got some other stuff, but this is the first DUI, correct?
Yes, sir.
All right. Any questions?
No, sir.
Have a good day, sir. Ma'am, he'll be downstairs 30, 45 minutes. Okay. 30, 45 minutes. You can wait here. You can wait down there. You can go and leave and come back. It's entirely up to you. Okay. Yes, ma'am. At the top of our list, we have Kayla Brock. Mr. Brock, good morning. Mr. Brock, you're here for first appearance for a hold out of Holmes County. I took a look at that case just so I could tell you if there was a bond or not, and it looks like a violation of county probation charged with no bond. So, Mr. Brock, you're going to be held with no bond until you can get to Holmes County. It could happen today. More than likely, it'll be in the next couple of working days. And when you get there, you'll go to another first appearance. Any questions, sir?
Yes, sir.
Have a good day, sir. Ian Rogers.
Good morning, sir.
Mr. Rogers, good morning. Mr. Rogers, you're here accused of one count of battery domestic violence. Mr. Rogers, there is probable cause in the complaint. As far as I can tell, I think you're entitled to a bond. I don't see any probation issues, and I don't see any pending charges. Let me listen to the attorneys, and then I'll address your bond status. Mr. McDaniel?
Your Honor, we just asked for a bond or maybe a cash bond if the court feels inclined.
Mr. Mitchell?
If he wants to take a cash bond, state doesn't object, but we're actually going to ask also for random UAs. Also, there were mentions of potential drug use listed in the complaint, I think with marijuana and maybe meth. So we would request the court to impose that condition.
Okay. I think that's the standard conditions of, well, it's not on a conditional release it is, but not on a bond. There is a reference to that. Them finding a glass pipe and a bong. Okay. Mr. McDaniel, any response to that?
No, Your Honor.
Mr. Rogers, I'm going to let you pick between a regular bond of $2,500 or a cash only bond of $250, cash only. You will have a condition of random urinalysis, and you will have a condition to have no contact with the alleged victim, no contact at all. And I know the living situation is not real clear, at least from the complaint. She supposedly was moving out. If she's moved out, you can live there. It's no problem. If she's still there, then you've got to find somewhere else to go. You can have no contact with her. So, Mr. Rogers, you understand your choice between the cash bond and the regular surety bond?
Yeah, I'm not sure with like the difference of it, but I mean, I'll take the cash bond.
Okay, it's $250 cash with those conditions. As soon as you post it, you'll be released. The jail will also give you a notice for your court date.
Yeah.
August 31st at 9 a.m. will be your court date. Any questions?
No, sir.
Have a good day, sir. We have Billy Peacock next. Has anyone came in for first appearances? I know we've got arraignment docket, but is anybody here for a first appearance case? Mr. Peacock, good morning. Mr. Peacock, you're here because you've been accused of one count of possession of cocaine and one count of possession of drug paraphernalia. I've read the complaint. There is probable cause. It appears you're already on probation for cocaine. So let me listen to the attorneys and I'll address your bond status. Mr. McDaniel.
Your Honor, it is the state of Georgia, and I think the rules that have to be associated with that won't allow him to do a violation of probation until he finishes up the sentence here. Or,
I forgot about that. I think that they have help me remember. We had one of those we held, and
It's the rules associated with the Interstate Commerce Act that
They
says that
can't put a hold on them until they get the warrant.
until they resolve the case in the presiding state. So essentially, they can't get a warrant for them for violation. You know, if you go to visit another state while you're there and you commit a crime, you're going to stay there until you finish up whatever happens in that state before they bring you back to the.
Because we had one time where I placed a 7-day hold and probation department did a letter to request that they be dropped because they couldn't put the hold on them. Is that right?
It is. It's part of the interstate process they have under the rules, I guess, the federal government have set up. So when they honor the first state, if somebody's in their state and they come here while they're on probation, let them come over here. If they violate a crime, they have to finish up that case before they take them back.
Okay, I'm pulling up the DOC page to see
That's my
if
bad.
it shows anything. It just says interstate. It doesn't say what state.
It's Georgia, it's Seminole. It's right across the border, Donaldsonville.
Okay, Mr. Mitchell.
Judge, given those circumstances, we're not asking that a 7-day hold be put in, but we are requesting that he be subject to random UAs.
Mr. Peacock, I'm going to set your bond at $10,000 on the cocaine charge, $5,000 on the paraphernalia charge. Your bond is $15,000. I'm not going to place a 7-day hold on you for the reasons the attorneys have already put on the record. You do have a condition of random urinalysis on this bond, Mr. Peacock. And if and when Georgia gets a warrant, if they ever get a warrant, you have to deal with that. But right now, I don't think we can place a hold on you because it's not a Florida sentence that you're serving. Mr. Peacock, do you have any questions?
I'm still lost.
You got a bond of $15,000 cash or surety. And you have the right to post the bond, but you're still on probation. You still got to report to the probation office like you normally would. Any questions?
Well, what all am I being charged for?
Possession of cocaine and possession of drug paraphernalia.
Which that is what? Paraphernalia.
Paraphernalia is like a packaging that contains illegal drugs or a pipe. I think in your case, it was allegedly a pipe, some type of device used to ingest illegal substance.
Okay.
All right. Have a good day, sir. Yeah, please give him a court date too. August 4th at 8:30.
Yes, sir.
Did you say the 6th or the 4th?
Felony should be the 6th.
We've got the 4th. We've been giving people the
Oh, no,
4th
it
for
is
a couple of
the 4th. I'm
weeks.
sorry. It's the 4th.
Okay. Yeah, August 4th.
Yes, Steve.
We have Brenda Hamilton next.
Usually they have a hard time. I know the cutoff's today, but I know sometimes I know it's last month on the Mondays, by the time they get them into the system, they won't put them in there till tomorrow. So, and it'll probably be for the next month after that.
No, they can put it on yeah, they should put it on today. If they don't, let me know. We'll
It didn't last
get it
month.
fixed. Ms. Hamilton, good morning. This is State versus Brenda Hamilton. Ms. Hamilton, you've been accused of 1 count of possession of methamphetamine, 1 count of possession of cocaine, and 1 count of possession of drug paraphernalia. Ma'am, there is probable cause for the charges. Ma'am, I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney, and then we'll see what the state's position is. Mr. McDaniel?
Just bond, Your Honor.
Mr. Mitchell?
We request she be subject to random UAs also.
Ms. Hamilton, ma'am, I'm going to set your bond at $5,000 on the methamphetamine, $5,000 on the cocaine, $2,500 on the drug paraphernalia. That makes your total bond $12,500 cash or surety. Ma'am, you do have a condition of random urinalysis. Ms. Hamilton, you probably would be a candidate for conditional release to an inpatient drug treatment program. In the meantime, you've got the right to post the bond. If you post the bond, you'll be released. If going to an inpatient drug treatment program is something that interests you, that you think you'd benefit from, you'd want to talk to one of the drug treatment specialists, either through the sheriff's department, Ms. Colbreth, or through the jail. Still has Chaplain Pippin out there. But in the meantime, you've got the right to post a bond. If you feel like you want to go to inpatient drug treatment, then you wouldn't need to post a bond. I would see you in the course of the next several days or the next week or so and find out what program we're going to send you to. But you've got the right to post a bond if you wish. You're going to use the phone in a few minutes. The jail's also going to give you a notice for your court date, August 4th at 8:30. Do you have any questions?
I have to post bond because I've got animals I moved yesterday and my livestock I have to feed, and I haven't made any arrangements.
Okay. Well, you've got the right to use the phone in just a few minutes, ma'am.
Okay.
West Weeks. Mr. Weeks, good morning. Mr. Weeks, you're here because you have two different issues, 3 charges in 2 counties. Calhoun County's first. Calhoun County, you have a charge there, and it has a cash bond on it. It's some type of registration issue with a motor vehicle, a criminal case. It has a $432 cash bond. So that's Calhoun. Jackson County, you have 2 new charges, possession of methamphetamine and possession of drug paraphernalia. And in those charges, I have read the complaint. There is probable cause. Also looked at your criminal history, which is very lengthy. But I think you're entitled to a bond as far as I can tell. Let me listen to the attorneys. Then I'll set your bond. Mr. McDaniel.
Nothing, Your Honor.
Mr. Mitchell.
We request to be subject to random UAs.
So, Mr. Weeks, your bond's $10,000 on the methamphetamine, $5,000 on the paraphernalia. The reason your bond is that amount is for 2 reasons. One, your criminal history is so bad. Number 2, you've already got pending charges in another county. So your total bond is $15,000 in Jackson County. You have a condition of random urinalysis on that bond. Do you have any questions?
Yes, I do. They didn't find anything on me. I was in my cousin's truck and I just got in that vehicle and I told them, they said they did an inventory search.
I advised you before, Mr. Weeks, I advised you when I was at the jail that there's nothing you're going to say that's going to get you out of this. So you need to.
I'm not trying to get out of it. I'm trying to get a lower bond because it's not. You didn't have nothing to say. You didn't have nothing to say a minute ago, so you stay there. Let me ask the judge a question.
All right, you want to go ahead, sir.
What's your question?
My question is this. I just asked for a little, I know I got criminal history, but you can see it's been a long time since I come in front of you. I'm asking for a lower bond just because it's not my vehicle. I didn't find anything on me. I'm just give me a little mercy on that. That's all I'm asking, Judge Mercer. If you would. I'll tell you, I'm glad for random UAs, but that's been since 2019.
2024.
I haven't been in front of you in 24.
I don't know if you've been in front of me, but you were charged January 12th of 2024, possession of drug paraphernalia. Let's see where this was at. Jackson County Sheriff's Department.
No. Couldn't have been. I hadn't been in front of you since you sent me to prison.
Let's see what the system shows here.
2019, and I was sitting on a false charge.
Give me a second, Mr. Weeks. I'm looking up your criminal history on the computer. Sometimes it's easier to read on a computer. So it's a 23 case, but you were in court in 2024. Let's see what this charge is. 23-50 CF is the case number. 3 counts of possession of controlled substance, 1 count of possession of paraphernalia. Your first appearance date was January of 23, January 31st, and then you were back in court January 12th, 2024. Plea waiver entered in absentia. Let's see what this is. Enter a plea of no contest. Let's see what the sentence was. In these cases, you were sentenced to time served. So usually that's when you have cases somewhere else and they're cleaning up this case.
I got involved in a murder investigation that I wasn't even there for. That I had nothing to do with it. That was some crazy stuff that has nothing to do with me. I was doing a job at somebody's house and got arrested there.
Yeah, last charge before that was also 2023, and that was no motor vehicle registration, which is the same thing that they want you for in Calhoun. Maybe that's the same one.
No, it wasn't no motor vehicle registration. I had it.
No, that's different counties. The same charge, different county, different case number. Mr. Weeks, your history is horrible. That's your bond, sir. I wish you the best.
All right, I'll pay it today.
Have a good day. We have Amy Hicks. Ms. Hicks, good morning. You're here for first appearance accused of 1 count of habitual driving while license suspended, ma'am. There is probable cause in the complaint, and I looked at your history. It looks like you have 2 or 3 of these exact charges in the past, ma'am. So I think you're entitled to a bond because as far as I can tell, you're not on probation anywhere. And as far as I can tell, you don't have any charges pending. So listen to the attorneys, and then I'm going to address your bond status. Mr. McDaniel, anything? No. Mr. McDaniel?
Nothing, no.
Mr. Mitchell?
We just request you have a condition of no driving at all.
Ms. Hicks, your bond is $5,000 cash or surety, ma'am. You have a condition not to drive a motor vehicle based upon your driving record as well as your criminal history. You do have the right to post the bond. You'll get to use the phone in a few minutes, ma'am, to try to post the bond. The jail's also going to give you a notice for your court date. Ms. Hicks, your court date should be August the 4th at 8:30, and someone at the jail will give you that notice in just a few minutes. Do you have any questions?
No, sir.
All right, Ms. Hicks, wish you the best, ma'am.
Thank
Thank you.
Yes, ma'am. Sarge, I think that's it on my list. Anything else for first appearance purposes?
No, sir, that's everyone.
Thank you. Mr. Mitchell, anything else from the state?
Nothing from the state.
Mr. McDaniel?
Nothing else.
Ladies and gentlemen, that concludes our first.
All right, that's it for Wade Mercer this morning. Good morning once again. About to enter hour 2 of TCF Live. Good to have you all here. Let's go to Texas. The
You,
Judge
Austin
West
Jones?
Fashion Show.
And Mr. Jones, this is your initial appearance in cause number 26, DCCR 1137. You are charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from March 26th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Jones, is reset your case for about 30 days to give you some time to try to hire someone. Well, if you bond it out, then I expect you to at least try to hire someone. So I'm going to give you 30 days to try to do that. And if you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They all have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? You'll step in front of the clerk. She'll give you a reset notice. Cedric Martin Harris. Cedric Martin Harris. Morning, Matthew. Last page. Bond will be forfeited for non-appearance and reset at 100,000. Lance White. Good morning, you're Lance White?
Yes, ma'am.
And Mr. White, did you get a lawyer hired?
Spoke with Mrs. Brittany Holmes. She told me about just to get some paperwork from you or something for her to be my lawyer. And I spoke with Mr. Durham out in Houston, Texas, and Rowan Harris.
Okay.
I spoke with Miss Brittany Holmes. She wouldn't even, she just told me, "You've been to court?" I said, "Yes, ma'am." She said, "If they give you a piece of paper, the paper I had."
So your reset notice. So here's the thing, like with, so Ms. Holmes was appointed to represent you when you were in custody. So technically she's your attorney, but you can either hire her or hire someone else. It's so where are you on being able to get one of those attorneys hired?
Durham charged me, told me the consultation for my case would be, they would charge me for grant to be my lawyer. And I wouldn't be able to come up with that amount.
Sure. Who else did you talk to?
Ron Harris.
Okay.
And he's a little higher than Durham.
Okay. Did you talk to anyone else?
Besides that, 3, Brittany Holmes, Ron, and others.
And did Ms. Holmes, did you talk to her about hiring her?
I didn't even get there far with her. She just told me to get some paperwork from you guys and bring it to her office. I don't know what type of paperwork.
Well, that's if you have a court-appointed attorney. Are you working?
Yes, ma'am.
Okay. Where are you working?
I work at Basin Hotel in Port Arthur.
So it just depends, Mr. White, on your income and your bills. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk on the end, she'll give you that paperwork. Tevin Edmondson. It's okay. It's all right. I see you got, don't worry about it. Good morning. And sir, you're Tevin Edmondson?
Yes, ma'am.
And Mr. Edmondson, were you able to get someone hired?
I was originally gonna go with Miss Brittany Holmes, but I had this accident, so my funds kind of got messed up. So I spoke with Mr. Marvin Lewis, and he's willing to work with me. So this evening I will meet him. If you can give me like a week or 2 week reset, and I have more information for you.
Okay, so you think you're gonna be able to get Mr. Lewis hired?
For sure.
Okay, well, I'll give you just a normal reset. That'll give you 30 days,
Yeah.
right? So if you get Mr. Lewis hired, just bring the reset notice that you get today to him. He'll tell you what to do. If for some reason that's not going to work out, talk to some other attorneys, see if there's someone else. If there's still an issue because of your accident, just bring me some documentation of that and then we'll talk about your options, okay?
I apologize again for this.
It's okay. I totally understand. Thank you, sir, for the apology. Step in front of the clerk. Marin Ezel or Ezel? Good morning. Are you Marin? Is it Ezel? Ezel. And Mr. Ezel, this is your initial appearance in cause number 26 DCCR 1062. You're charged with theft of property with previous convictions from April 8th of 2026. Your indictment alleges several prior offenses of, well, it looks like a few of theft, and then there's some possessions back in 2009. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am.
Let me look at something real quick. So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, then I'm ordering you, or then just bring the reset notice that you get today to that lawyer if you hire someone. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you talk to, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. You understand?
Yes, ma'am.
Step in front of the clerk. She'll give you your reset notice.
Fairly tame Monday morning fashion show thus far. We will check back in, of course, but let's march across the hallway. Say good morning to Judge Stevens.
No, there's 2 indictments, right? I thought this said a motion to revoke. Well, that's motion to revoke probation hearing. Two MTRP hearings? On
I got 2 brand new phrases.
is that right?
Probably right, Judge.
Hold on. I don't see a MTRP.
I don't either.
But it's showing MTRP on the docket.
He was on probation at the time of the office.
We may have revoked him on one already, and that's on old notes. Let me look.
It's not what this shows on the file. I don't have any MTRPs in the files.
This is your fault.
It says he was indicted on these new indictments just in December of last year and January of this year. There's no way. Well, did we put you on probation in these cases?
No, sir.
No.
Not yet.
But it's showing MTRP hearings. He's not on. It's a new file. These are new files. Anyway, that's what are we going to do? I guess because it's 7 months old. Just sitting around, nothing.
Just to update you, the MTRP gets disposed of in March of this year. Those are just old notes that were attached to those cases, but he was sentenced on the MTRP in March.
MTRP for what?
He had a family assault that he was on probation for.
What's the number on it?
We've already taken care of it.
No, what?
24 DCCR 2199.
Okay,
And he received 10 years at PDCJ on
okay,
that case.
that's right, yeah. Okay, these are two new cases,
Yes.
two brand new cases. Oh, okay, so what are we gonna do? He's just sitting around in jail and he's got a 10-year sentence out there. Sitting around in jail. Well, we gotta move these, right? One way or the other?
Give me a couple minutes to look at them. I hadn't had a chance to look at them this morning, but I'll talk to Mr. Burbank real quick. We'll see if we can't move them. If not,
To Keldrum Elam.
I'd ask for a little more time on that. We're still collecting discovery.
How much time?
4 weeks.
4 weeks. We set 4 weeks on Elam, please. A request of defense, Charles Seegers.
It's a murder charge. He asked.
Survey has.
Trial document.
Okay, that's March. It was indicted in March. Where are you on this?
I could probably be ready to.
Oh, you're announcing trial? Okay, all right. He's got. No, that's not an enhancement. I don't know.
All right, I will keep an eye as we await the next contestant there, but let's just go back across the hallway. New contestant approaching Judge West.
Belvin?
Yes.
And this is cause number 25 DCCR 1485. Mr. Belvin, it looks like was accepted in a pretrial diversion, and we're just checking in. Mr. Nicole.
Judge, my notes from Ms. Molfino indicate that he is participating and being successful so far in JCDI,
Okay.
and that they expect that to continue, and that'll end up taking care of this case once he does complete the program.
How much longer?
She was asking for a 3-month reset, 90 days.
90 days.
Yes,
Okay.
sir.
We'll do 90 days.
It's a year program that I've been there 3 months, so 9 months.
he has 9 months left.
Okay, we'll do 90 days, and at that time, if you'll get with Ms. Molfino the week before, and if everything's going well, we could probably do a
Okay.
reset without everybody having to come down.
Appreciate it.
before. Just let me know, but make sure that week before, talk to
Okay.
Ms. Molfino, she can check on it, and y'all just send me a
Okay.
message.
Okay.
All right.
Thank you, Your
Appreciate it,
Honor.
sir.
Thank you for
Jasmine Jaquette, that door's locked, Mr. Belvin.
Your Honor.
Jasmine Jaquette. Good morning, ma'am. Are you Jasmine Jaquette? Yes, ma'am. And this is cause number, spit your gum out in that trash can over there.
Here, all right.
This is 26 DCCR 0240. Ms. Jaquette is charged with deadly conduct, discharging a firearm. Mr. Parker?
Your Honor, we're asking for reset. I've talked to Ms. Malfino about this, and I think there's a co-defendant.
Judge, I have the co-defendants in this case, and it's going to end up, I'm going to have this one reassigned to me. And so I would ask for a reset also, just so Mr. Parker can get with her about what her options are.
Okay, sounds good. So, Ms. Jaquette, I'm going to reset your case about 30 days or so. Stay in touch with Mr. Parker so that once he gets with Mr. Nichols, he'll know what your options are, have all of the discovery, and you can, we'll get an announcement at the next court day.
She has actually called me.
All right, good. All right, good. We'll see you the next court day. You're free to go. Let's see, there's a sentencing, Mr. Parker, on Marie Lopez.
Done agreed.
Morning. Morning. Good morning, ma'am. Are you Marie Lopez? Speak up.
Speak up.
Yes. And this is cause number 24, DCCR 0886. Ms. Lopez was previously in court, entered a plea of guilty to the state jail felony offense of driving with, while intoxicated with a child passenger. There was no agreement in this case. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Have you?
Yes, Your Honor.
Any additions or corrections?
None more of you.
Not from the state.
So I want to start, I guess, with Ms. French on this one. This is a very typical kind of case where probation is typically the outcome. And so I guess I'm curious. Obviously, I understand and I saw the facts, and that gives me some concern. But I think there's some treatment and things like that that could be. I guess tell me, what's your position?
I would like to see Ms. Lopez get some kind of treatment. My primary concerns based on the evidence that was presented in my file and also with the PSI was that the substance that was being abused and the fact that Narcan had to be administered. That was very disturbing from the state's point of view. And if there are, we know there are programs regarding substance abuse, maybe issues with parenting, decision-making, definitely decision-making skills. There may be some kind of mental health issues or situations that she needs help with along those lines. The state is going to defer to the court on this one, but certainly we would hope to never see Ms. Lopez here again.
Ms. Lopez, I don't disagree with what Ms. French is saying. This was a very scary situation and could have turned into something really, really horrible with your children. And so what I'm going to do today, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated with a child passenger. I'm going to sentence you to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. I'm ordering you to pay a $1,000 fine and to follow all of the rules and conditions of probation. Those are several things that are kind of typical. Also, there's going to be some that are especially for this offense. One is that you will enter and successfully complete the JCDI program. That is an intensive outpatient drug rehab program. You'll be required to follow all of the rules of that program. You're also going to be required to participate in any mental health services through Spinaltop. So we're not trying to set you up to fail. What I want you to have is all of the tools necessary to be able to be successful. So if you're going to do a substance abuse assessment as well, if there's any other specific treatment that probation or that assessor thinks is necessary, then you're going to be required to do whatever it is that they ordered or that they recommend. Do you understand?
Yes, ma'am.
If you do everything you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over. You will be able to serve your sentence out on probation. The other side of that, though, is if you violate any condition of probation at all, you will be back in court and you could be facing the 2-year sentence that I've already given you. Do you understand?
Yes.
Can I make a request, please?
Sure.
I mean, Miss Lopez is, I couldn't ask for her to be more cooperative with me and taking care of a case and taking it serious. She just, I mean, I'm sure the court has seen it in the PSI, but this is a wake up call to her, what she's told me. She doesn't have a significant history at all that I know of. She, after this incident, she has been required to wear a drug patch. And I get reports all the time that they're negative throughout her whole time on bond. Additionally, last week she called me freaking out because she took her kids to a water park and the patch came off. She said, what do? I said, call whoever installed it and tell them. And she said, I've already done that. So well, you ought to be fine then. So she went and got it replaced. She has got her associate's degree. She's got a job. She's trying to better herself even further, trying to become a physical therapist. And she's already taken a parenting class. I'm just wishing she could get deferred because I'm worried about the conviction. That's right. You're right. You're right, Judge. You're correct. You can't.
Yeah, I wouldn't
Right.
disagree with any of that.
I wouldn't think of that. You're right.
Yeah, unfortunately, that is, I mean, there is a new on the misdemeanors where they can on some, but I don't
Right.
think. I can
You're,
do
you're,
that.
you're right. Because we had this before.
Okay. All right. So, I'm going to hand you the trial court certification. It shows this was not an agreement. There's some rights to appeal. You can talk to Mr. Parker about that. If you'll just have a seat here in the courtroom. What? Yes, ma'am.
Firearm admonition. This is an adjudicated.
Oh, thank you. Also, I'm going to hand you a written admonition regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. So if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right. So just have a seat in the courtroom. Probation is going to call you to her desk when she's ready to go over your paperwork. So just watch for her to call your name. Good luck to you, ma'am. Thank you, Mr. Parker. Thank you, Ms. French. Jorge Quezada to sentencing.
I haven't seen him yet this morning.
Jorge Quezada.
He's coming to the valley.
Jorge. His bond will be forfeited for non-appearance and reset at 100,000. And if you get in touch with him and he's on his way, just let me know.
I'll check. I've got calling her.
Calvin Smith to sentencing 2 cases. Good morning. Are you Calvin Smith?
Yes, ma'am.
And Mr. Smith was previously in court in cause numbers 25 DCCR 1638 and 1639, entered pleas of guilty to those offenses. And I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir. Yes, sir.
Any additions or corrections?
Not from the state.
All right, Mr. Smith, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. In cause number 25 DCCR 1638, defer all proceedings and place you on probation for 5 years. Order that you pay the $1,000 fine and follow all of the rules and conditions of probation. In cause number 25 DCCR 1639, also, defer all proceedings and place you on probation for 5 years. You're ordered to pay a $1,000 fine in that case also, and to follow all of the rules and conditions of probation. If you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, the cases will actually be dismissed and you'll never have the felony conviction. The other side of that is if you violate any condition of probation, then you can be brought back into court, found guilty of the offense, and sent to the state jail prison in one case for up to 2 years, and sent to prison in the other for between 2 years and up to 10 years. Do you understand? And I know there were some issues based on this offense and when you had your wreck, and I know your mom's helping you. You need to make sure and follow all of the rules. If you need help, if you're having trouble understanding and things like that because of the injury, then you just need to make sure, have her come with you, talk to probation so that you know everything you're supposed to be doing, so you don't not do something you're supposed to. Does that make sense? All right, I'm handing you in each of your cases the trial court certifications. This shows that these were agreements that I followed, so you did waive your right to appeal. You need to have a seat in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. So just listen for her to call your name, okay? Good luck to you, sir.
Okay.
And then you've got Regina Williams. You can hold that. This was the last.
It's a rejection.
Do you have anything, Anna? I don't have any. Mine's just empty.
All right, friends, we will keep an eye on Judge West, of course, and probably be back. But let's go back to Florida. Judge Mercer is not done with his day. He's got people in the courtroom now.
Right court date.
Well, I went through PBA, and this past Friday I was notified through the PBA guy that I talked to. He said that he sent me my representative's number, and it was like 3 minutes before he closed. So I tried calling my representative and I couldn't get no answer. So he told me to just come today and ask for a continuance because I hadn't heard from mine.
If that private attorney has filed a notice of appearance, which they have, we're going to give you a court date.
Okay.
And what date is that for? September 10th at 1:30 is going to be your court date, ma'am. So just go ahead and contact your attorney between now and then. That attorney should get a notice also.
Okay. Thank you.
Ask her a question.
Sure.
Is the PBA representing all the other, because none of those other correctional officers are here.
There's one here, but none of the other ones.
There are 5 total defendants.
They filed notice this morning or something?
One file.
Okay. Okay, so that's why I'm there.
We'll address that afterwards.
So just make sure you stay in contact with the attorney before the court date, okay?
Okay.
Have
Thank
a good day. So that was Miss Pitts. Jalen Poole. Mr. Poole's on the not guilty side. Tapua Redding. Private attorney. Jarena Rosario. Demetrius Sanders. Takia Thomas on the not guilty side. Timothy Wilson. It's on a no contest side. Okay, so if you're here on a case and I did not call that name, then that means we've got an issue, maybe on a different date, maybe in a different courtroom, maybe been dismissed. I don't know. Is anybody here for a name I did not call? Anybody else? All right, so next thing I've got to do is determine if you qualify for the services of the public defender's office. So I'm not talking to this side of the courtroom. The reason is you're not asking for a lawyer.
Judge, do you want to go ahead and take care of this one, or do you want to?
No, wait till I get to that.
Okay.
Please. So we want to see who qualifies for the services of the public defender's office over here. And I've got to look at a couple of things before I can qualify you. First thing I've got to look at is the bond amount that's posted.
Okay, friends. Well, they're still running people through the sorting hat from the sounds of it, so we'll let them do that. Maybe check back later. Let's go back to Texas, Judge Stevens.
James Bean, that's you, sir? And you're here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, so this indictment alleges, okay, we got 1, 2, 3.
You need counts, you need 2 requires for third-degree punishment.
Two of the bars.
Yep.
Your Honor, the state would waive the final or the last enhancement paragraph, or abandon, I should say.
I'm sorry?
State would abandon that last enhancement paragraph.
Paragraph 1, in summary, sir, alleges that on or about March 28th, 2026 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you're charged with here? But yes, yeah, you have to speak out so she can hear you. You have to use the language. Yes, no. Today, tomorrow. Okay. This would normally be a state jail felon, except paragraphs 2 and 3 allege that on May 10th, 2011, in cause number 11,260 out of Jasper County District Court of Texas, and thereafter on October 27th, 2015, in cause number 12596JD out of the District Court of Jasper County, Texas. You were convicted of burglaries of buildings, paragraphs 1, 2, and 3, since they're all state jail felonies. This is a state jail felony that will be enhanced by the 2 prior burglary of building convictions to 3rd-degree felony punishment. Do you understand where you stand on all of this? Yes, sir. Stand down. We're writing these up on those enhancements. They've got to be what the underlying crime is. So state jail felony punished as 3rd-degree felony. So that the records show it's a state jail felony. It's just punished differently. And there is a distinction in the records. And they want that to be shown that way. And so you understand what you're charged with in paragraphs 1, 2, and 3, 1 being a new indictment for the state jail felony of unauthorized use of a motor vehicle, and then paragraphs 2 and 3 being state jail felony burglaries of a building convictions in 2011 and 2015 out of Jasper County District Court. This constitutes a state jail felony, though it is punished as though it were a 3rd-degree felony, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? Yes? You have to say yes, so she can hear you. Okay. An agreement's been reached in all of this that you would be pleading guilty, sentenced to 4 years in prison. Is that your understanding? If I follow this, you have no right of appeal of your case. Do you understand? So how do you plead to paragraph 1 charging you with the state jail felony of unauthorized use of a motor vehicle? Guilty or not guilty? Guilty. Are you pleading guilty voluntarily and because you are guilty? Yes, sir. And the 2 burglaries of buildings in paragraphs 2 and 3 out of Jasper County District Court in 2011 and 2015 respectively, are those allegations true and correct as they are alleged in this indictment? Yes, sir. And are you pleading true and correct to each of those paragraphs 2 and 3 of those state jail felonies? Pleading true and correct voluntarily and because those are indeed prior convictions of yours? Yes, sir. Okay. I show you what's marked as State's Exhibit 1. Did you sign those documents, understand them, discuss them with your attorney? Are the contents true and correct? State's Exhibit 1, without objection admitted. This states you are mentally competent to enter your guilty pleas freely and voluntarily made. You know what you've been charged with. Documents have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. Yes. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here. Yes, sir, it is. I'm going to follow this agreement if nothing further to add by the parties. I'm going to find, Mr. Dean, you have pleaded guilty and truth, respectively, to paragraphs 1, 2, and 3, voluntarily, knowingly, intelligently. And that is enough to find you guilty based upon paragraph 1, which states under oath that you are guilty of these offenses and you are mentally competent to enter your pleas and you understand and appreciate the consequences of pleading guilty and you are guilty of these offenses and all lesser included offenses and all of that is true. So help you God. So you're pleading guilty to paragraph 1, the state jail felony, and true to paragraphs 2 and 3, the prior burglaries of buildings of state jail felonies, which constitute here a state jail felony, punished though as it were a third-degree felony. I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened today on all of this? All right, that is all. Thank you. For the record, that was not the actor, James Dean. That was an individual.
Well, thank heavens he cleared that up. Good morning once again, everybody. Hour 2 of TCF Live. Good to have you all here on this glorious Monday morning. Let's march across the hall. Judge West.
Yes. That's okay. Thank you. Good morning. Are you Virginia Williams? Yes, ma'am. And let's see. Give me just a second to get this close. Judges 2-1 rejection.
Oh, I only did one. I did, Judge. Yes.
Is it the same
Yes.
to run concurrently?
Yes.
The objection to me filling that in?
No, Judge. Sorry.
All right, so Ms. Williams, in cause number 26, DCCR 0218, you're charged with a state felony offense of theft of property with previous convictions. That's from November 25th of 2025. Your indictment alleges you were previously convicted of theft May 12th of 92, and then 3 cases, January 11th of 1994, again, October 9th of 2006, April 13th of 2011, May 2nd of 2012, October 6th of 2014. And then your indictment further alleges that you were convicted of forgery, a third-degree felony, August 4th of 1995, 2 cases on that day of forgery, and then another of securing execution of a document by deception. And then after those were final, you were convicted of possession of a controlled substance, a third-degree felony, December 18th of 2017. Well, what that means is that if you go to trial and you're found guilty and all of those prior, or at least some of those prior convictions are true, you would be facing punishment as a second-degree felony, which is between 2 years and up to 20 years. Do you understand? Yes. And I have here, and that's in both of your cases. The second case is 25 DCCR 1430. It charges theft of property with previous convictions, and that one's from August 9th of 2025. Again, with those same prior convictions listed and the same possible punishment range. You understand that as well. Yes, ma'am. And then I have a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to proceed on count 1 only for an 18-month state jail term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand that before we go to trial, what your options are and what the possible consequences are if you go to trial. And do you understand all of that? And you want to reject that offer and have your case set for trial. Have both cases set for trial. Okay. I do want to also make sure you understand that after today, I will not accept this plea agreement. This plea agreement is already extremely low for the criminal history, even though some of it's very old, it is significant. And so and it's fine, if you're not guilty of both of these offenses, then that's what a jury's for. So I'm not trying to talk you anything. I'm just trying to tell you that I'm not going to accept this plea agreement after today. Do you understand? Okay.
Just for the court to where it is that one reason it's been reset is they're supposedly, people are going to sign a non-prosecution affidavit. Well, affidavits that she's not the one that did it, and she has got it signed, but it's not notarized. And I told they need to go to the DA's office. So that's the only.
And
thing
y'all
I see.
haven't had anybody come to do that?
I don't think so. This is not my case.
I cannot hear you.
This is not my case. It's for the small fingers.
Okay.
But she has not. No, nobody has been there yet.
Hold on. Okay. Ms. Williams, if I test you this morning, will you have anything in your system? No. Have a seat in the jury box. We're going to double test that before I reset it for trial.
I'm gonna go check in.
Okay. Mr. Rojas? Mr. Samuel? Mr. Wasserstein? Good morning, Guadalupe Reyes. Good morning.
On the way up, he understands what's going on. Judge, I have my assistant going to help to translate. We're going to reject the offer today.
Okay, you need to do that in writing. There's a plea bargain rejection on the tablet, and then I'll call it up, and by the time she can be up here and help me go through that and make sure he understands all of that.
Yes,
Okay,
Your Honor.
I'll hold it.
Go ahead and do it.
All right,
I'm
thank
sorry, we had a little emergency in the parking lot with a different county and a Zoom.
Okay,
deals that-
that's okay, no problem.
He's on
Yeah,
it.
no problem.
We'll get it done, Judge. Thank
Sure,
you.
and they can, if you need some help, I'm sure one of the attorneys can.
I probably will.
Okay.
Thank you.
Alrighty, friends, let's go back up to Ohio. Judge Colada again. Looks like we're going to have another sentencing there.
Shapiro. Thank you, Your Honor. Your Honor, I've been before the court this morning in the matter of the state of Ohio versus Nicole Henderson, actually two cases, Your Honor, 26 CR 420 and 26 CR 439. We're before the court for purposes of sentencing in both of these cases. The defendant having pleaded guilty and been found guilty in the 420 case of the lesser included offense of count 1 being F5 escape and count 2 F5 vandalism. And then in the 439 case, the defendant pleading guilty and found guilty of count 2 F3 robbery, count 3 F5 possession of cocaine, and count 6 F3 tampering with records. Parties are ready to go forward, Your Honor.
Thank you. Mr. Levy, any reason not to go forward with sentencing?
No reason, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. And thank you to the court for ordering and having prepared the number of evaluations, including the pre-sentence investigation report, as well as the psychological report from Lake Geauga Recovery Centers. I'd like to first focus, Your Honor, on that psychological report from Lake Geauga, excuse me. It indicates, Your Honor, that my client has been previously treated and diagnosed with anxiety, depression, post-traumatic stress disorder, borderline personality disorder, bipolar disorder, among other items, as well as heavy drug addiction, that she has had an extremely difficult past She suffered sexual abuse as a child. She later was a victim in a human trafficking matter, and certainly her ongoing drug use led to the instant offense. I would indicate, Your Honor, that the report indicates a very thorough and detailed treatment plan should she be given an opportunity on community control, and we would ask that the court would consider an opportunity on community control. That includes a recommendation for NeoCap, dual diagnosis residential treatment program, sober living, full psychological evaluations, and other treatment recommendations should the court consider community control in this matter. Your Honor, certainly my client has accepted responsibility for her actions. She was treating and on methadone, Your Honor. She relapsed. She was significantly drug addicted. She was purchasing drugs from less than wholesome individuals and owed them a good deal of money. She was in a situation where she either needed to obtain the funds to pay them or believed that she was going to be forced back into prostitution if she couldn't pay for the drugs that she had previously purchased and not paid for. That led to this incident, Your Honor, where she was initially in a store, had a cart full of items, was approached from somebody who worked at the store and turned around almost impulsively and threw a deodorant at them, not striking that individual. Certainly under the law, that is basic grounds for a robbery, which she accepts responsibility for, Your Honor. I would submit, until I attended law school and familiarized with myself with the laws in Ohio, that is certainly not what I would think of as a robbery offense, even though certainly under the law it is. But I would submit to the court that that is probably one of the lower forms of the offense when looked at it as a whole. This wasn't something with a firearm or a knife or a serious...
Yeah, but this is an F3 robbery. It's not an F1 robbery and F2 robbery. It's an F3 robbery.
It is, Your Honor.
So you can't compare an F3 robbery to an F1 robbery and F2 robbery.
Certainly, Your Honor. But I would submit that she threw a stick of deodorant, Your Honor. After that, she still needed to obtain money, went to another location and was engaged in the same behavior. When approached by authorities, she gave her sister's information knowing that she had a warrant out for her arrest, Your Honor. She's extremely apologetic. She knows she shouldn't have done it. She knows she's going to face consequences from this court, and she's prepared to face those consequences. She would just request, Your Honor, if the court were to impose a prison sanction, the agreed recommended cap by the parties was 4.5 years, that the court would not impose more than that time, and at the appropriate time would consider a motion for judicial release and additional treatment. I think, Your Honor, she has completed NeoCap before. It was 10 or more years ago. I don't think she's really ever taken treatment seriously. She has had her third child. She understands that she needs to be there for her children, regardless of whether she serves a prison sentence or gets out. She needs to treat, and she needs to get help, and she's of no use to her family unless and until she does get that necessary help. And would just request, Your Honor, that the court, however it deems fit, would give her an opportunity to get that. She's been suffering for the better part of her life, Your Honor, from mental health, from drug addiction, and I think she is truly ready to face treatment head on, make those difficult decisions and choices, and separate herself from whoever she needs to separate herself from, and really put forth the best effort she can to obtain the help that she needs. Your Honor, we had agreed to restitution. I believe the state's going to ask for $75 in restitution for a GPS strap, and my understanding is that there's 126 days of credit for time served. She has been in the county jail during the pendency of this matter, Your Honor. I know she's going to accept responsibility and apologize to this court. I believe she truly is apologetic and has indicated from day one when I first met her that she really and truly does need treatment. This isn't something that she has said to me as part of her sentencing or is just saying to the court for the first time at sentencing. It's what she has expressed to me from day one when I first began representing her in this matter. Your Honor, we thank the court for the time this morning, and we know that the court will fashion a sentence that is appropriate.
Thank you. Ms. Henderson, you have two separate cases here, and you have the right to address this court regarding both of those cases and say whatever it is you'd like me to know or consider. Is there anything you want to say at this time?
Yes, there's so many things I want to say, but first, I know I'm here to take accountability for my actions, and they got me here today, and the choices I made leading up to this. The true meaning of taking accountability is confessing what I did wrong and not giving excuses for that afterwards. So, I was wrong when I left the hospital and I cut the ankle monitor off. And the Lake County Sheriff's Department was only trying to help me and my unborn baby. I was wrong for the way that it is going to affect the next person who gets put in this situation, and I truly apologize for that. I was wrong when I left my mother's house after being sober for a couple months and having my baby sober and relapsing instead of continuing to try to get into rehab and continuing to try to find a way there, because I was actively trying to get into rehab. I showed up at Hitchcock House with inside the gates and they denied me. I sat there and tried to switch my insurance over and they told me there was a 14-day waiting period. I also had a bed ready in Ashtabula, and my mom's car was broke down. The lady who was taking me to the methadone clinic 3 times a week all the way out off of 55th and Euclid at CAAA. She was supposed to take me to rehab 2 separate times and did not answer the phone that day. And it's not nobody's responsibility but my own.
You said you're not making excuses, but that's what I'm hearing.
Huh?
You said you're not making excuses, but that's what I'm hearing.
Okay, you're absolutely right. I was wrong for using drugs that I did not have the money for. I'm sorry for continuing for the drug problem. I was wrong for stealing groceries, and I apologize. Okay. This letter was just me admitting to every single charge and apologizing for it. And yes, I'm adding things into it even though I don't mean to. And I apologize for everything that I did. I apologize for not doing what I'm supposed to be doing. I'm not asking to get rewarded because of anything. I don't deserve it. I just don't know what to do at this point in time. I really don't. I don't know what. I don't. I've been doing this for so long. I just don't know what to do, and I sincerely apologize. I need help. I don't know how to live in the real world like every single one of you guys. I've been doing this for so long, and yes, I've never went and took myself to treatment before. And I don't know why I haven't. Other than what I've done since I've been out of prison last time, I need help, and I need somebody to help me, and that's so crazy to say because I'm an adult. So I don't know what to think and do. I don't know the next step to take. I know it. I just don't know how to take it. I just don't know what else to do, and I just need help. I really do. And I'm really not trying to make excuses. I'm not trying to explain anything. I'm not trying to do none of that. I'm just here to ask for help and to apologize for everything, the community, the stores, my mother. I apologize to my mother, my kids. I apologize to my sister for using her name. There's so many things that I don't know. I don't want to give up. I need help. I need help, and I know that probation will be on me about doing this if I listen to them, and if I really want this, I will put in the work every single day to do it, and that for the rest of my life. But even after probation, I don't care if I get 5 years on probation with NeoCap and everything. I don't just need treatment. I need to learn how to think right, to make decisions right. I need help with my trauma that I've been in. I need help with my addiction. It's all leading to one from another. It's not just one thing. and I just don't know how to do it myself. And I've sat here and done this so long that my family just, when I ask them for help, they're done with me too. And I don't know what to do, and I apologize, and I want to just be a normal person. And I just keep saying I don't know what to do because I don't know what to do. I need help. I do. And I'm just asking for it. I'm asking, I want to say a chance, but I don't deserve a chance, and I said that. I'm asking to build trust to get that chance. I understand that if I don't do what I'm supposed to be doing, that the probation department is very capable in going to get the people that violate within a week. I've sat here for 4 months and seen the same people come in 2 weeks after they get out. And when I was on probation 10 years ago, it only took them a month to come get me. So it's not trying to get out and thinking I'm going to get away. It's never that. I really want this, and I need it. And I have to make up to so many people what I've done wrong to them, including my family, my new baby, my older 2 sons. And maybe even one day help somebody like me. Because there's so many of us females out there that just nobody understands what we go through. And I don't know, I apologize. I really do. And I just need help, and I'm just asking for it. And I will show the court, I will show you, I will show my son, I will show myself, I will show my God that I deserve this when I am able to get this help. Because as of right now, I don't deserve it. But I will show you that I am worth it. I am worth saving. I'm not worth just throwing away and continue to do this. I don't know what else to say.
Well, I mean, is there anything else you'd like to say? You don't have to say anything more, but I just want to make sure you've said everything you want to.
No.
All right, thank you. You may be seated. Mr. Levy, anything else you want the court to consider?
No, Your Honor, thank you.
All right, please be seated. Mr. DePiero, on behalf of the state of Ohio.
Thank you, Your Honor. The defendant has said repeatedly what she believes she needs is help, help, help. From the state of Ohio's perspective, what she needs to do is no longer commit crime. She has gotten help in the past from this court, from Judge Shirley Strickland Staff School downtown. She's been in our jail treatment program here in Lake County twice, once in 2016, once in 2022. She went to NeoCap. Now, that was 10 years ago. But it's the most intense treatment that we have, and it's supposed to stay with you. And instead of it staying with her, she just reoffended and kept reoffending. She had medically assisted treatment. She was ordered to an inpatient program. She left after 4 days. And so, I representing the state of Ohio, I have to hear what the defendant says, and I have to question either she doesn't have any insight or she just can't do it. I don't know. But we can't have any more people getting hurt because she is going to use drugs and has mental health problems. Certainly she, it appears, has had a very difficult and hard life, and I'm sorry for that. But she keeps hurting people. She hurts her sister by using her name and signing her name on booking records when she gets arrested. And if we didn't have observant police officers who did their job very thoroughly, her sister would have yet another official record in her name of a crime that she did not commit. And that's serious. That's serious. We're talking about felony crimes here. She went. This wasn't simply throwing a stick of deodorant at the employee at Giant Eagle who's just there doing his job. There was a tugging match with a shopping cart full of $1,600 worth of groceries and merchandise that the defendant was trying to leave the store with. So this isn't a matter that she took a candy bar and is walking out, or some makeup or something and is walking out. I mean, this is like organized criminal activity. She's doing it with somebody else, and it's premeditated. This isn't a thought she had in the moment. She sought out to do it, and when she wasn't successful, she immediately went somewhere else. When they arrested her or when they detained her in Walmart, she had a whole shopping cart already full. It wasn't even that much longer. Okay. So this is sustained conduct that is criminal, where people keep getting hurt. Certainly, the state is sensitive to her upbringing and her problems, and God help me, I hope she gets it together, because we don't want her hurting anybody else. So the state believes prison is appropriate, is called for under the purposes and principles of sentencing. The state does believe that no more than 4.5 years total with both of the cases would be appropriate here, given the circumstances. She did take responsibility. I acknowledge that. I thank the court for highlighting during the plea hearing that the escape charge has to be consecutive to all the other counts. I didn't realize that, and for reminding us here today of that. Also, by agreement, would ask the court to order the defendant's voluntary forfeiture of the glass smoking device that had the cocaine on it in this case, and to order $75 restitution to On-Track Solutions, which is the cost that they incurred from cutting off the ankle bracelet. The defendant does have credit for 126 days served on each of these cases. Thank you.
Thank you. This court has considered, you can be seated, please. Thank you. This court has considered the pre-sentence report and investigation, psychological evaluation, considered the facts and circumstances of the offenses involved, the nature of the offenses involved in both cases. I received correspondence from the defendant, have read and considered that. I received a victim impact statement from the defendant's sister regarding the tampering with records count. I've read and considered that. I've considered everything that's been said here today by the defendant, her lawyer, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 29.29.11 of the revised code. As for the factors in 29.29.12, in 26 CR 439, that's the robbery charge with the cocaine, the tampering with records. Tampering with records is more serious, as the defendant's relationship with the victim, and that her sister facilitated that offense. And it has caused her extreme emotional stress, quite frankly. I got a letter from her. You've been doing this for years to her. And not only does it affect her quote criminal history that she doesn't have, but it also medical. You go to the hospital and you tell them you're her. So now her medical records are tampered with and wrong. And she goes there and they look at medical records and it's got her coming in with your medical conditions that she's got to deal with. She's been going through this for years, and you just keep doing this to her. And it's not as simple as just using her name. She's the one that's got to deal with the fallout from all that. Getting arrested, getting stopped by a police officer for her simple speeding ticket and having a warrant out for her because you're using her name. Looking at her criminal record, and it's your criminal record. Again, going to a doctor's and having her medical record show all your issues. Why does she have to deal with that? But you just keep doing it over and over and over. The impact it had on her, it makes it more serious than the normal tampering with records case that we deal with, because normally it doesn't have that effect on individuals like that. Nothing makes any of these offenses less serious. As for recidivism factors, almost all of these are present. The defendant has an extensive criminal history going back 20 years. So you're only 36 years old, if I'm remembering correctly. Let's make sure of that for the record here. 36 years old. And your record goes back to 2007 as a juvenile. And it's continued on as an adult. You've served multiple prison sentences, 3 I think at least, by me, that I've had to impose. And that's after I initially give you an opportunity of probation. You have failed to comply with previously imposed sanctions ordered by courts. I've been dealing with you for 10 years now. You've been given chance. You sent me a letter, you read a letter. This is your case from 2016, this is your case from 2019, 2022 is on here. Got all the same letters from you. I read all the old letters. You say the same thing in the letter that you wrote me just last week. Nothing changes. You say everything that you think I want to hear, and you don't do it. You need to be there for your kids. Started off as 1 kid, I think, now up to 3. But you need to be there for them. You're tired of living this way. You're going to hang around different people, new people. You've been telling me this stuff for 10 years. Literally the same stuff. Initially I hear it and I say, all right, maybe she's being sincere and genuine here. But now this is the 4th case you've had with me telling me the same stuff. And how am I supposed to believe that's sincere and genuine? Because you tell me the same thing every time, and you go out and do the same thing. When you were in jail, you couldn't even follow the rules. You were repeatedly violating rules in jail. Now maybe they're not real serious rules, but they're rules first of all, and secondly, you're doing them over and over, the same thing. You're going to do what you want to do. It's as simple as that. Your score, your ORIS score, is one of the highest I've ever seen. It's a 41. I think the highest, I'm not sure, it could be 43. You say what you think we want to hear. Maybe you believe that in the moment as you're sitting here, but as soon as you're out on your own, you're going to do what Nicole wants to do. You committed this robbery charge when you have warrants out for you for the escape charge. Nothing indicates recidivism is less likely. I mean, with the history here, recidivism is almost guaranteed. Under 292913B1, court finds defendant previously served a prison term. Prison is consistent with the purposes and principles of sentencing. And again, there's just no way this court can make the finding that be required in order to put you on probation that you're amenable to community control sanctions. Therefore, it'll be the sentence of this court. Then in case 26 CR 439, on count 2, charge of robbery, defendant served a term in prison of 18 months. On count 3, possession of cocaine, defendant served a term in prison of 9 months. On count 6, defendant served tampering with records, defendant served a term in prison of 18 months. Court's going to order that the 18-month prison terms in counts 2 and 6 be served consecutive to each other. Count 3 will be concurrent with those charges for a prison term of 36 months in this case. Balance of the charges in this case will be dismissed. In case 26 CR 420, an amended count 1, charge of escape, felony 5th degree, sentence the court defendant to a term in prison of 6 months. The vandalism charge in count 2 is a term in prison of 6 months. By statute, those have to be consecutive to each other for a prison term of 12 months. And by statute, that prison term must be consecutive to the prison term in 26 CR 439, and I'm ordering that be consecutive. Since it's consecutive, she gets credit for 126 days on one of the cases, and it'll be in 26 CR 439. There's no credit in 420. So with both cases, it's an overall prison term of aggregate of 4 years in prison with 126 days of credit. In 26 CR 420, I'm going to order restitution to On-Track Solution, the amount of $75. In both cases, defendants ordered to pay all costs. 420, not 420, and 439, I'll order the voluntary forfeiture of any drug contraband and instrumentalities. Further, in 26 CR 439, I need to advise you that upon your release from prison, you will be placed on post-release control. It's mandatory in this particular case for at least 1 year, could be up to 3 years. While you're on post-release control, if you're violating the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Post-release control is optional for up to 2 years in 26 CR 420. The same condition, if you violate any of those rules and you're put on post-release control in that case, you'll be sent back to prison for another 9 months for each violation you commit, up to an overall total of 50% of the prison term imposed. Any additional prison term imposed for post-release control violations is being imposed as part of the sentence at this time. Court further finds in 26 CR 439, I order that counts 2 and 6 be run consecutive to each other, and I find that consecutive service for those counts is necessary to protect the public from future crime and to punish the offender, that they're not disproportionate to the seriousness of her conduct and the danger she poses to the public, and that her history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. And quite frankly, that finding applies to running 26 CR 420 consecutive to 439 as well, even though it's required because of the escape charge. Even without that mandatory provision, I would run a consecutive for that same reason. I think that covers everything that I can think. Mr. DePiero, is there anything I missed or need to address?
I'm sitting here thinking, I don't see anything, Judge. No, thank you.
Mr. Levy?
I don't believe so, Your Honor.
All right, thank you.
All rise.
So I put in the poll. Is it just me, or is this one of the worst people we've seen in a while? 93% of you agreed with me. As tragic as it is that she's been separated from her children for 4 years, and as much as I hope that there's a family member or responsible adult that has them and they're not stuck in the system, regardless of their current situation, they are better off than they would be in this lady's hands. I don't even know what to say about her. Hopefully she gets help. Hopefully she gets her life turned around. But as I put in the chat earlier, I'm not, I would bet good money against that, to be honest. There's just something there that I don't see it working, but hopefully I'm wrong. Michael, thank you for gifting a membership. You got Jasmine. That's very cool. Now we just need Lisa and Tammy and Jonathan and anybody else I'm missing. Turn the chat green. Okie dokie, let's go. Where do I want to go? Let's go back to Judge Stevens. Let's do that. Let's make that happen.
Motion to revoke probation. Dave DeVille.
Oh, no, I've already got it.
25 CR 729 is now called the State of Texas versus Jay Kennett. DeVille, that's you?
Correct.
with your attorney, Mr. Dusler, and the state's attorney, there is
Quick pause since they haven't gotten started. Lindsay answers the call with 10 memberships. Barbara answers it with 5. Let's see, are we hitting on anybody here? I mean, obviously we are, but anybody currently in the chat? Swung on and a miss, it looks like. But thank you both very much. Very generous, and welcome to all of our new members. Back to Judge.
a motion to revoke unadjudicated probation. It's been filed as of June 5th, 2026. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes, sir.
In summary, and raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Correct.
Lower your hand. In summary, this motion alleges that on August 4th, 2025, almost a year ago to the day here, that you in this court were placed on deferred or unadjudicated probation for 10 years for the second-degree felony of aggravated assault with a deadly weapon. Is all of that true and correct?
Correct.
All right. Number 1 states you failed to report to the Jefferson County Probation Office for the months of April and May of 2026 in violation of your probation order, which states you shall report regularly and monthly. Is that allegation true and correct?
Correct.
Are you pleading true and correct of voluntarily and because it is true as it is alleged?
Correct.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that would be enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked. You can be found guilty and then sentenced up to the full range of punishment. This is a second-degree felony. You are on probation, or you are looking at no less than 2 nor more than 20 years confinement in prison. Understanding that, do you insist on pleading true today?
There's no agreement. You're pleading true to this and the judge to make a determination.
Well, there's no agreement on it?
That's correct, Judge.
You understand the consequences, what you're facing. It's up to that amount, the full range. No, I'm stating to you, knowing that, do you insist on pleading true today?
Sure.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Here, allegation 2 is something we need to deal with. This states you failed to remain compliant with attending rehabilitation, treatment, residential, or counseling. You rejected the rehabilitation opportunities while you were in Baptist Hospital in May of 2026, and that violates condition 12 of your deferred or unadjudicated probation order, which states you shall attend rehabilitation, treatment, residential programs, and counseling as directed by your probation or officer and provide verification of such. Is that allegation true and correct as it is alleged? That you failed to remain compliant with attending rehabilitation treatment as ordered by the court?
I completed Baptist, but I did not go to
The rehabilitation?
rehabilitation.
Okay, why?
I was working a job and trying to make some money to pay off probation, and then I was going to afterwards.
Yeah, but the job is important. You know, it pays for things, but this gets you revoked and sentenced up to 20 years. It could. All right, is that allegation true?
Yes.
It's not true that you failed to remain compliant with attending rehabilitation treatment?
True. It is true. Okay.
Okay. Have you had enough time to think about it and talk to Mr. Dusler about all of this? Do you feel comfortable being up here?
I'm okay.
Okay. Okay, number 3 states you failed to provide verification of performing community service hours as required. How many community service hours has he completed since August 4th of last year?
164, Your Honor.
Okay. How much did he fail to complete?
For the first year, he has to complete half of his 800 that were assigned.
Oh, 400?
Yes, sir.
Okay. What happened on the community service hours? What was he required to do for community service?
I asked him to come to the office. We have community service there that we offer. And I mean, he was compliant like once a month, but I really wanted him to come more often.
Okay. Are you pleading true to allegations 1 and 2 here, failing to report and failing to remain compliant with attending rehabilitation treatment? Are you pleading true to those 2 allegations voluntarily and because those are true as they are alleged, sir?
Sure.
You understand that a knowing and voluntarily made plea of truth of 1 or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can now be revoked. You can now be found guilty for this aggravated assault with a deadly weapon and sentenced up to the full range of punishment, which is no less than 2, no more than 20 years confinement. Knowing that, do you insist on pleading truth today? I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Sure.
Who is Jason DeVillier? How are you related to?
My father.
All right. There's no agreement on this.
That's correct.
So I'm going to ask the parties what y'all suggest. I'm looking at the criminal history summary based upon the public safety report that I have here. I don't have a pre-sentence report with me because we purged those.
I have the copy of the original PSI, Judge.
Okay. And it looks like the defendant has some prior convictions.
That's right.
Here of theft of property in 21. He was placed on probation. It's misdemeanor, placed on probation. That was revoked and sentenced to 30 days. Indecent assault was convicted and was sentenced to 90 days. Theft of property convicted 90 days confinement, all jail. Criminal trespass convicted 90 days confinement. 23 was not a real good year. And then let's see, criminal trespass to habitation, 90 days. Then also in 23, convicted 20 days, county jail in Angelina County, evading arrest or detention in 2025, convicted 40 days confinement. So, well, let's see, 1, 2, 3, 4, 5, 6 misdemeanors that I'm looking at. And then this deferred that he's on, but he was on deferred in 2013. I guess he successfully completed that. I guess. Doesn't say. Stand by. And there was an arson probation that he was on in 2017. I guess he successfully completed that. Okay, here. Thank you very much. I knew the DeVilliers syndrome. I grew up in Groves. I knew John DeVillier and Russell DeVillier. That was your grandfather, maybe, or no? Well, they have to be related somehow, but they would be older. They're older than me, but they knew my father better. But they were very, John DeVillier was a very famous newspaper sports writer for the area. And Russell DeVillier was a very well-respected man. Okay, so there's no agreement here. What do we do? Go ahead, Don, you can go first.
Judge, he's wanted to remain on probation. And
there's a way to do that, and that's not commit violations like you've admitted to here.
Fortunately, there are no
How much
new
time? Thank you.
Fortunately, there are no new criminal offenses, and I think the probation officer correctly stated that, he's made attempts and he reports, but just not as regularly as he should. And he's done a bunch of his community service, but again, not as regularly as probation would like him to. I think because he's on the mental health initiative and that he's making attempts, we don't have any new offenses that would benefit not only him, but everybody in general, to have him continue to be monitored in probation. And we would ask that the court hold this matter in advance and allow him to continue on probation.
What state's name?
Yeah, the court's hit on what I was going to hit on, which is the criminal history for this defendant. He is fortunate, given that criminal history, to have even been given this opportunity with community supervision. And the fact that he squandered that opportunity, Judge, and wasted resources that could be devoted to other defendants who would benefit from community supervision, I think is the real travesty here, Judge. This is not the first time that he should have gotten the message. There was an administrative hearing back in May of 2026, and that didn't get his attention, Judge. I'd ask that you revoke his community supervision, reform the judgment, and assess no less than 5 years TDCJ.
Sanction for 5 years. Imprisonment. This is your chance to speak if you wish, Mr. DeVillier. Can you explain all of these problems? And can you explain what kind of plan you might have to fix your decisions that you're making that are consistently wrong? You can fix it. I mean, what's right and wrong. What's causing the problems? We got to communicate here. I'm quit being a mind reader a long time ago.
Right.
What do you want to do? Do you want to go?
I would like to continue with probation.
Do you? Okay. This isn't the way to do it,
Right.
It's simple enough to revoke and sentence you and we move on. But how many chances do you get? We rattled off all kinds of convictions here for misdemeanors and then probation. If you don't report regularly, you're not on probation. We have to supervise you, and we can't come and find 5,000 probationers. We have 5,000 probationers at any given time. We can't go and look for you. You have to report. You have to do your part. If you don't report, you're AWOL. Were you ever in the military?
No, sir.
When you're AWOL, they find you and put you in a rig, and they don't give you a medal. You're not on probation if you can't report. You got to do your part. You're on your own probation, which isn't the way it works. And then counseling here, you've got to help yourself fix the issues that you have so that you can be the very best you can be. But once again, we're not going to go find you like you're in the second grade because you lost your way to the classroom. You're an adult. You're responsible for doing your part. And we're going to make it available, but at the end of the day, it's you, the probationer, who has to do the heavy lifting, not the probation office. Or do you want me just to revoke and then you go to prison and then it'll get behind you after some years? But this is a aggravated assault, whatever you're sentenced to, because there was a deadly weapon use, you're going to have to serve 50% of your time. So if you're sentenced to 20 years, you're going to do a decade in prison, a decade, and you only have 89 days credit.
You think
That's a whole generation almost.
you think you could successfully complete probation, do what they've asked you to do? That's what we're asking the judge.
Right, well, yes, sir.
Oh, wait a second. Let me just refresh your memory. When we placed you on probation, you signed right here, right after my signature. I have received a copy of this probation order. I agree to follow all conditions imposed upon me, and I know that this community supervision can be revoked for any violation. What was this? I agree to follow all conditions imposed upon me. Here we are. You can imagine how your promises don't mean too much anymore. You had been on probation for a year. Here you are. Not doing the most important thing, and that's reporting regularly. Well, what state?
We're asking for revocation, Judge. No less than 5 TDC.
Okay. And probation.
Whenever he was given probation, his mom didn't want him to live with him, so he was staying at his grandma. He was working at Taco Bell for a good while, up until February. And then his grandma called me and actually came to the office and said, hey, he got fired from Taco Bell because he stopped going because he was drinking at night. I didn't include this as a new violation because I never tested his alcohol because I never got a hold of him again. But his grandma kicked him out of his house. He was staying at hotels. So if he does get probation again, I'm not sure where he will stay. His mom didn't want him to begin with, and then his grandma kicked him out of her house.
Where are you going to stay if we continue you on probation? If we do that, where would you stay?
Yes, I didn't know I couldn't go back.
Oh, you just heard that for the first time?
Right.
Well, you can imagine, I mean, why wouldn't they consider that after what's going on here? Fix this. Got a phone on in there. Yep. I don't want people, there's a big sign that says turn your phones off. And I'm looking at the guy's phone as he's walking out, but yeah. All right. Well, we can't put him on regular probation because he's got a deadly weapon finding. So it's either revocation or continue. I'm reluctant to send him to prison for a long time for these types of violations. But it's still a violation. It only takes one. He's on the mental health case law too. How's that working out?
He was doing fine up until February. And I don't know if he stopped using medication because...
Where are you working? Okay. Where are you working now?
Working now?
Yeah, if you're continued on probation, where are you working? Who do you
I'm
work
gonna work at Walmart.
at? Walmart?
Yes, sir, Walmart, Goodwill.
They're going to get you back to work if you were released?
Sure. Well, I would assume so, yes, sir.
Here's what I'm going to do. I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by preponderance of the evidence or to greater as allegations one and two are proven true. I'm going to continue the defendant on this deferred or unadjudicated probation. You're going to do 10 more days in the county jail. Then you will be released and follow these terms of condition and conditions of probation. They're there for your best interest, but all you're doing is shooting yourself in the foot by not reporting and not remaining compliant with the counseling. Those are vital. You can imagine next time you're not going to be given a lenient option. And once again, it's up to 20 years in prison, and this is 50% that you have to serve, which means a decade. But it's your choice. This is all, you're only here because you made a choice not to do the right thing, and you are able to do the right thing. Fix this for your own benefit. I mean, we're trying to help you. Fix this, please, or else we don't have another choice. Okay, that is all.
Thank you.
See the probation officer. Thank you.
Now in the final half hour of TCF Live, yet another day flying by. Good to have you all here with me today. I hope you're having a good Monday so far. Let's go, we'll stay in Texas, but following this channel's promise of 9 to 11% more Judge Boyd, let's go to San Antonio.
Court is calling 2024 CR 007778 and 2026 CR 002899, State versus Christian Grant O'Keefe. Could I have parties announced?
Galloway for the state.
James Hunt for defense.
And are you Mr. O'Keefe? Sir, did you review the motion to revoke community supervision and cause number 2026 CR 002899 with your attorney? Did you understand it?
Yes, ma'am, I did.
And did you review the motion to enter adjudication of guilt and revoke community supervision and cause number 2024 CR 007778 with your attorney? Did you understand it?
Yes.
Are you the same Christian O'Keefe who was placed on community supervision in 2026 CR 002899 for the offense of possession of a controlled substance, penalty group 1, 4 to 200 grams on March 27, 2026 for a term of 4 years, and the same Christian Grant O'Keefe who was placed on deferred adjudication in 2024 CR 007778 for the offense of assault, family, household, impeding breadth of circulation on October 31st, 2024 for a period of 6 years. Is that you?
Yes, ma'am.
All right, state.
Judge, will be proceeding on the same violation and each cause not a violation of condition number 1 on or about the 30th day of June 2026 in Bear County, Texas. The defendant Christian Grant O'Keefe committed the offense of evading arrest or detention in violation of condition number 1.
How do you plead to that? True or not true?
True.
Will waive an amendment.
Any objections? Did you understand by pleading true to violation of condition number 1 and cause number 2026 CR 002899, the court could find it true, grant the motion, and sentence you up to 4 years in the prison and up to $1,000 fine?
Yes, ma'am.
And did you understand by pleading true to violation of condition number 1 in 2024 CR 007778, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to that violation?
Yes.
Then in each cause number, the court will find violation of condition number 1 true. Is there a proposed agreement?
No, there is not, Judge. And regarding the cause number ending in 2899, we are asking that the court grant the state's motion for revoke the defendant's supervision sentence 4 years in the prison. And regarding the cause number ending in 7778, we are asking that the court grant the state's motion and turn adjudication of guilt against the defendant on revoke his supervision sentence 6 years.
All right.
We were in agreement on 4.
Oh,
Yeah, yeah. Okay.
So then we do have an agreement for consideration, Judge. Sorry.
Okay, and
4 years. Direct.
all right. And counsel, is that your proposed agreement?
That is right.
And Mr. O'Keefe, are you asking the court to follow that agreement?
With the agreement of running a back time, Your Honor, yes.
All right, so here's the thing. You need to listen to the questions that I'm asking you. Are you asking the court to follow that agreement you reached with your counsel? Are you waiving your right to appeal? And state you may be excused. And cause number 2026 CR 002899. As previously stated, the court is finding violation of condition number 1 true. The court will sentence you to 4 years in the prison. Give you credit for any time served. There's $1,000 fine. Time and money will run concurrently. There's to be no unsupervised contact with minors and no residing in households with minors. And this will run concurrent with 2026 CR 002899. And that cause number, did you review the document? I'm sorry, this will run concurrent with this will run concurrent with 2024 CR 007778. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Next, we're proceeding in cause number 2024 CR 007778. And that cause number, the court will find violation of condition number 1 true. Court will sentence you, the court will grant the motion, revoke, find you guilty, and sentence you to 4 years in the prison. This will run concurrent with 2026 CR 002899. There's a $1,500 fine. I'm sorry, let me repeat everything. So that's 4 years in the prison, credit for any time served, $1,500 fine, time and money to run concurrent, no unsupervised contact with minors, no residing in households with minors. This run concurrent with 2026 CR 002899. There's an affirmative finding of family violence. And there's to be no contact with to review the trial court certification of defendant's rights to appeal with your attorney. Did you understand it and sign it?
Yes.
All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. Make better decisions. What's happening with the number 1 case?
I'm going to go down
taken care of?
I'm going to go down to 12 right now and see.
All right. Well, if he needs to be transferred, you'll have to let the deputies know.
Okay.
Thank you.
Thank you.
Alrighty, friends, we'll stay in Texas, but go back to Judge West, new contestant there.
Sir, are you Austin Tebow? And this is cause number 26, DCCR 1102. Mr. Tebow is charged with publishing or threatening to publish intimate visual material. And what is the announcement?
Yes, Judge, I believe this is Mr. Gallagher's first setting. We're just asking for a reset to work through discovery.
All right, any issues? I'll just do a normal reset, Mr. Tebow. That's about 30 days or so. Make sure you get in touch with and visit with your attorneys before the next court date so you can go over all of the discovery that they've received, and we'll see if we can get an announcement. All right, you're free to go. Thank you. Mr. Kimler, you've got Charles Beard. Okay, here with us? Yeah. So should we just bring them over tomorrow? Or do I do at large, I guess, in this case?
I think it's a new case.
I didn't check what it was.
I'm not sure.
Can you tell when you look at it what, okay. This is Miss Molfino's case on Charles Beer.
I think his mother is here.
Hmm.
His mother is here.
What does he see? Why he's in our, he's in jail. So we need to, I'll just need. It does say parole violation, not a new case. You don't have, do you have any notes or from Ms. Molfino that shows any new case?
There is an evading and a theft from September that appeared to be pending. He is on parole through 2036, so.
Those are misdemeanors that are already pending.
It doesn't say here on it.
Can you tell if he also has misdemeanors? Oh, so there's a new case as well. Burglary of a habitation from June 25th.
We don't have that yet.
And June 23rd for burglary of a building. And March 1st for possession, all while on bond for this case. So I'm gonna find that he is at large without proper bond in this case and reset the bond at $100,000 in this case. All right, Evelyn Odom, the sentencing.
Judge, we had agreed on a misdemeanor reduction for her to do 30 days. It's just her essentially throwing herself in. There's no order.
Got it. Good morning, ma'am. You are Evelyn Odom. And Ms. Odom was previously here on cause number 26 DCCR 0403, entered a plea of guilty to a lesser offense of Class A misdemeanor evading arrest or detention. And I reset it for sentencing. Ms. Odom, have you been arrested for anything between when you were here to plea and today?
Yeah, me.
All right, then any reason not to go forward?
No, Your Honor.
All right, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of evading arrest or detention. Sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody previously on this case that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff. And then you've got a sentencing, Mr. Kimler, on Michael Serrant. Good morning. Are you Michael Serrant?
Yes, Your Honor.
And Mr. Serrant was previously in court, entered a plea of guilty in cause number 25 DCCR 1691 to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor. Yes, Your Honor, we have.
Any additions or corrections?
No from defense. No from the state, Your Honor.
All right, Mr. Serrant, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, however, follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. There is a recommendation for some spinal tap treatment. I didn't really see a lot of issues with that. So what I'm going to do is just order an assessment first, and we'll have a mental health assessment done. If there's some issues that need to be addressed, then whatever that is, if there's any, you'll be required to follow whatever treatment recommendations. You understand?
Yes, ma'am.
All right. If you do everything you're supposed to when you're on this probation and follow all of the rules successfully, then at the end, this is the case will be dismissed. It's a great opportunity. You don't have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and you could be sent to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork, so just listen for her to call your name.
Yes.
All right, good luck to you, sir.
Thank you.
Mr. Lewis, you have Marvin Davis. Morning. How are you?
All right.
Yep, it's Monday.
I know.
Good morning, sir. Are you Marvin Davis?
Yes, ma'am.
And this is cause number 26 BCCR 0754. Mr. Davis is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Judge, we've gotten an offer from the state that I do need to go over with my client some more. Also, he's involved right now with his parenting plan and everything going on with CPS. So part of that is that we're trying to let him get a little further down for us to complete some of those classes.
Sure.
Before we proceed. So we're asking just for one reset.
Right. Any issues? that you
No
see?
issue, I see. Your Honor.
All right, I'm going to reset your case, just a normal reset. It's about 30 days. Make sure you follow through with everything on that safety plan. That's only going to help you in this case as well. All right. Stay in touch with Mr. Lewis. He'll let you know when your next court date is. All right. You're free to go. Lance Charbino, Mr. Lewis.
Morning, Your Honor.
Good morning. You're Lance Charbino.
Yes, ma'am.
And this is 25 DCCR 0096. Mr. Charbino is charged with credit card or debit card abuse. And what is the announcement?
Judge, we're asking if we could set this for a plea for next week. He will be able to have that restitution by tomorrow. Should be, so we be able to have that paid before we come back.
Okay. Any issues, Mr. Nichols?
That's fine, you stand.
All right, we'll reset it 1 week for a plea. So it'll need to be taken care of next Monday. All right, thank you.
Judge.
And then Mr. Mitchell, did I see Mr. Mitchell? I thought I did. Let's see.
All right, they're going to need a minute or two to rack up the next contestant, so let's march across the hall. Judge Stevens.
That's what I have. That's what I have. But I'm looking at,
Oh, I see what you're talking about. Okay.
all of these are separate events is what I'm saying. He's had 15 violations over his probation that we've had to deal with. These are all separate. They don't repeat them.
You must have something different than I have. This is what I have. 2 days.
Yeah. Oh, you're missing a third page.
Missing a page. Okay, I'm sorry.
I'm sorry. You're missing a third and fourth page.
Yeah, I'm done.
Okay, thank you.
You're welcome.
Yeah.
In any event, Judge, we do have an agreement.
Maybe not.
Okay.
Y'all made an agreement,
Right.
but I mean, it's,
Yes.
it's, first and reversed, first amended. What do we do with it? There's nothing on the first amended that was filed in 23. I have nothing on this that showed that we disposed of this. Do y'all have any history on this?
I do not, Judge,
I didn't represent it.
and I just inherited.
Well, it was filed in going on 3 years ago. Has he been an absconder or something?
He went to TDC, Judge, so I suspect that out of a different county.
Don, please.
Family violence.
Well, there's nothing, we never dealt with the first amended that was filed in 3 years ago.
Well, he's been in TDC.
For how long?
Or that,
For how long?
3 years.
Well, I did 11 months in Galveston County, did 2 years.
When did you do the Galveston County? Galveston County, what, the date?
When I got there October 2nd, 2023.
2020 what?
2023.
Okay. All right. What is, how much were you sentenced to then?
3 years and a half. I ran CC.
And Judge, the state's original offer was 5, and Mr. Dusler worked me down to 3 on this, Judge.
So explain to me how subsequent bad behavior results in less punishment.
That's not normally my policy or my thinking either, Judge.
I believe.
I do believe that the sanctions should get progressively worse.
So, okay.
Well,
so why are we doing that?
Well, and Mr. Dusler made an argument that was somewhat compelling, and I was
committed.
I was wanting to move.
The point was that he's actually been in custody either in Galveston County, Harris County, or TDC now for several years. He's got quite a bit
but he's held accountable. But you just don't commit a bunch of wrongdoing and then package them up in a deal. You're held accountable for every mistake. That's what you're supposed to be, or else what it does is promotes people who, if you want to really foul up, do it great. Do it big time, make a big mess, because they'll package it up and sell it for 5 cents on the dollar. No, that's not right. No, that's not right. I know that y'all find it funny, but it's not right. There's nothing comical about this. People's lives and their liberty. And you just can't go and just make a big mess and think you're going to get a package deal.
I'm understanding every point to try to make Judge Stevens work. If I made he said I've been incarcerated.
When did you get out of jail?
February 4th of 2026. I was out on parole.
Okay. February what?
February 4th of 2026.
4th, okay. So 2 weeks later, you're committing failure to ID as a fugitive with intent to give false information in Harris County. That's what this says. In 2 weeks, you're committing a crime. In 2 weeks.
I'm trying to go back.
And 15 fail. Then 15 says you fail to report to the Jefferson County Probation upon your release. What's the word on, where's the probation officer on this, please? Who has information to help me?
Parole never even informed me that I was still having to deal with probation.
What are you saying? You were on probation for, I sentenced you to 10 years in prison, probated for 10 years in 22. 10 years to 22.
For 5 years.
Well, that's not what the motion says.
I'm showing 10 over 10, unless the motion's incorrect, Judge.
Well, let me see what.
I did not represent him at that time, but I think Mr. Gallimore, who represented him, had an agreement for a cap for 5 years, and the court granted him probation of 10 over 10 instead.
That's 5 years probation.
What did you say?
They granted him 5 years.
No, I'm sorry. This whole thing is going to be based upon you being forthright and frank with me, and I'm looking at the probation order that says that I signed that states 10 years, sir. Are you kidding me?
Real quick, while Judge is piling through the paperwork there, I'm going to go ahead and do an extra half hour today. We will go until the bottom of the next hour, since we got off to kind of a rough start, what with the restream dumping our first stream like 30 seconds in. So we will go to 12:30 Eastern, 9:30 Pacific. Enjoy.
5 days. The further due till
Well, friends, I just told you I'd go an extra half hour, but I didn't promise you there would be audio during it. I'm going to stick with it, though, because obviously there's a lot going on. He's going through so much paperwork, so we'll just ride out the silence here. But, yeah, we'll see where it goes.
All right, what's your version of all of this now? I think I figured this out. Go ahead. What were you gonna say?
Just, I don't intend to do any more crime, Your Honor. I wasn't even trying to get out on the parole. I mean, the PR bond that they set me out on, they told me I didn't have no detaining for over here when I was trying to come over here to resolve it. Like I told parole then, the reason for me not going to the halfway house was because I didn't even know my way around Houston. I'm not from Houston. You know what I'm saying? And
Everybody figures it out. You have to figure it out.
I didn't have no phone. I didn't have nothing. I lost all my credentials. It was hard for me out there. And I'm thankful to God that actually ended up coming down here. Like I said, they didn't have no detainer the 2 times they released me from Harris County. So they just kept releasing me back to the street. I had no support, no help. The person that I did rely on as support was the person that I had got the family violence.
Whose fault is all of this? Somebody else's?
No, it's my fault. I hold myself accountable to my actions.
You're on probation. What kind of probation are you on here?
They had me set for, to my knowledge and belief, was 5 years deferred adjudicated probation.
Is that what you think it is?
To my knowledge and belief, that's what I.
Are you okay mentally? Have you ever been seen by a doctor or something for mental health?
Yes.
All right. To help you out, this is a case that works its way back to 2022. Y'all, you and 2 other people assaulted a handicapped person who's confined to a wheelchair and assaulted him. So that in itself is not only criminal, it's just immoral. Then next, you were charged with injury to a disabled person. You were sentenced in 2021 by me to 5 years in prison. Then I granted you thereafter judicial clemency and placed you on probation in 2022 and sentenced you to 10 years in prison, probated for 10 years. You're done. Show him his signature to that.
Yes.
You signed off on the deal. See that?
That was your signature. That was after he granted you shot probation, he put you on 10 years probation.
You signed on it. You signed on the deal, sir. And this was in January of 22. You were convicted, then I gave you a break and put you on regular probation after sentencing you. You don't even, this is your life. I'm telling you some things you should know. You don't even know what you were put on. It's like you're not thinking squarely. Everybody knows what they're charged with. Everybody knows what their sentences are. And how could you be so confused?
To be frank, Ron, I wasn't properly medicated at those times. I was heavily self-medicating myself with.
Whose fault is that?
My fault is.
Then it's your fault. Yeah. And now we have a motion to revoke probation and alleging well, he never pleaded to the first motion to revoke probation. I mean, what we've got is a first amended and a second amended, 15 violations total. No, you don't assault a person in a wheelchair and get off lightly on my watch. So what is this deal? 3 years?
Yes.
No way. We're going to have a hearing on this.
Yes.
So when can you be ready for that?
Can I say something?
No, talk to him. I've already made my ruling. No, I'm not going to accept the deal. I'll make the decision and you're looking at up to 10 years in prison. But we'll have a hearing on this as soon as possible. When can you be ready?
Anytime.
This Friday?
No, sir, not this Friday.
Friday next?
I can get with her. I'm not quite sure about the schedule, but I'll get with her.
Well, I want to set it for Friday next and see where you are. Thank you.
Thanks, Judge.
It's not scheduled for me to speak to my probation officer at least. like,
Caleb Puente,
They should get in from Sunday.
Caleb Puente. You don't assault somebody in a wheelchair and think it's going to be forgotten. That's cruel. It's almost like throwing a baby out of a moving car. Those are the kinds of things that just bewilder me that go on in this room. What people are capable of doing when they want to do something wrong.
And of course, if you've watched TCF, you know that we had the baby thrown from a moving car thing just a few days ago. So, yeah, he's seen it all here lately. All right, we'll stay here. Looks like the guy's coming up now.
Does he need to go in front of you?
Is the NTRP?
Yeah.
No, it's good.
Right there. 25 CR 1735 is called the State of Texas versus Caleb Michael Puente. That's you?
Yes, sir.
Don Dusler is here, your attorney. There is a motion to revoke probation. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sir.
In summary, this motion, which was filed on May 8th of this year, it states, and by the way, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
In summary, this states that on March 31st of this year in this court, you were sentenced to 2 years in the state jail, and that was probated for 5 years for burglary of a building. Is that true?
Yes, sir, it's true.
Allegation 1 states that 3 weeks after you were placed on probation, you committed a theft of property on or about April 20th, 2026 in Jefferson County, Texas, which would be a violation of condition 1 of your probation order, which states don't commit an criminal offense while on probation. Is that allegation true and correct?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
You understand that true and correct admission to 1 or more violations of probation, that's enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Also, on April 20th, the state you committed the offense of being in possession of a prohibited substance.
Absolutely.
It should be a violation of condition 1. And commit a crime. Let's see.
It was a hollow metal socket that contained a burnt residue in the end. So it's a paraphernalia.
Is 1 good for everybody?
Yes, sir.
Yes.
Okay. Do you understand, once again, the consequences of pleading true here to allegation 1? Michael. Where are you, Michael? Yes. The agreement's been reached where you would be, your probation would be revoked. You would be sentenced to 18 months in the state jail. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
Right, I'm going to follow this agreement. Anything else to add?
No, sir.
I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater in this 25 CR 1735, the state of Texas versus Kayla Michael Puente. As Mr. Puente has pleaded true, voluntarily, knowingly, intelligently to committing theft of property while on probation. Your probation is hereby revoked, sir.
Yes, sir.
And I'm following this agreement. You are hereby sentenced to confinement in the state jail for 18 months. You need to be given credit for all time you have served. I'm looking at 70 plus days already. 70 plus.
Yes, sir.
So, So you'll be getting credit for that. Do you understand what has happened today? So anything else? That is all. Thank you.
Alrighty, friends. Jefferson County is where it's at. Let's go back across the hall.
Good morning. Are you Matthew Pham?
Yes, sir.
And this is 18-2969A. Mr. Pham has a motion to adjudicate on a probation filed. Underlying offense is theft of cargo. And what is the announcement?
Your Honor, I'd like a little bit of time, please, to figure out what's going on with these misdemeanor allegations. Those are also old, and those may resolve, which could help us resolve this. We're also potentially able to make a pretty significant payment towards the restitution. I've informed the state of that this morning, and I'd like to see if we had a little bit more time, also aware of how old this.
So this motion was filed back in 2022, and we haven't had any contact with Mr. Pham since then. Is that correct?
That is correct.
Okay, and it was pled down?
It's worded strangely in the motion, I think, but yes.
Mr. Smith, any issue with it? So it was pled to a third degree.
It's still a third degree. I believe it, but the amount was more than that, but maybe restitution was paid up front or something. I'm not exactly sure.
Restitution was ordered in the amount of $99,999, and it was pled, I guess, from a second to a third for a 10-year deferred back in 2019. And the motion was filed in 2022. I'm going to reset it one time. Mr. Pham, you need to stay in touch with Mr. Kelly because I'm not going to put it longer than about 30 days or so. All right. Okay. We'll see you back in 30 days.
Thank you, Judge.
Thank you.
So did I hear that right? That was $1 million theft of cargo? $999,999. Which makes me wonder, why did they come up with that number and not the million? Is this one of those sneaking cargo through at a certain dollar amount to keep it under a tax threshold kind of thing that corporations do? There's more to that story. I am curious.
She's my
Good morning, Ms. Cantu. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? Yes. Thank you, ma'am. And sir, are you Guadalupe Reyes? Yes. And Mr. Reyes, in cause number 25, DCCR 1422, you're charged with a first-degree felony offense of aggravated robbery from May 25th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it. Before you sign this, did you go over it with Mr. Wasserstein?
Yes.
Do you fully understand it?
Yes.
It shows that if you wanted to enter a plea of guilty, that the state is offering a cap of 15 years in prison which means you would leave your punishment up to me. But I couldn't give you more than 15 years. I could give you 15 or less. It would depend on the evidence that was shown to me at a sentencing hearing later. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
All right, then we will move your case to the trial docket. And Mr. Wasserstein will begin preparation. Stay in touch with him. He'll let you know when you need to be back and ready for trial. Right. Thank you
for the opportunity.
Thank you. You're free to go.
All right, back across the hallway. New contestant.
You want feedback a little bit? No.
Huh?
You want feedback? We call them back down. Go back and I know, but I mean, I didn't read that one. Well, I mean, but.
Okay, so this looks like it falls off the tracks with the motion to revoke unadjudicated probation filed December 29 of last year, which states the defendant was placed on 2 years deferred or unadjudicated probation for a state jail felony when it was clear she was ordered to be placed on deferred or unadjudicated probation for a Class A misdemeanor as of June of last year.
That's correct, Jeff.
So that falls off the track there, and then we move along. And there is a first amended motion to revoke probation, which continues the mistake of alleged filed in June, which continues the wrong allegation of a state jail felony. And she pleads true on June 29th, 26. What happened?
We had to sentence her to 15 months state jail.
All right. So that obviously is incorrect. That order is withdrawn. And the defendant is looking at up to 1 year in the county jail. So the court, I guess we pick up this first amended motion to revoke unadjudicated probation. The court is going to correct this first amended motion to show the defendant, instead of a state jail felony, class A misdemeanor. All right. So let's start over on this, right?
Yes, sir.
Raise your right hand again, ma'am. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this states that on June 17th, 2025, in this criminal district court of Jefferson County, Texas, you were placed on 2 years deferred or unadjudicated probation for the Class A misdemeanor of the lesser included offense. Stand by. Of attempted burglary of a building. Burglary of a building is changed and correcting all over this thing. So attempted burglary of a building, a Class A misdemeanor, and you were placed on 2 years deferred or unadjudicated probation. Is all of that correct?
Yes, sir.
Allegation 2 that you earlier pleaded to alleges that you admitted to the Orange County Community Supervision Officer who was supervising your probation that you illegally used tetrahydrocannabinol, marijuana, on or about August 9th, 2025, which would have been a violation of condition 10 of your probation order, which states do not use or possess any drug. Is that allegation true and correct?
Yes, sir.
Are you pleading true and correct to that
Yes.
voluntarily and because it is true?
Yes, sir.
Do you understand that a true and voluntarily made plea to one or more violations of probation, that's enough to grant a motion to revoke probation? Your probation can be revoked. You can be sentenced up to 1 year in the county jail. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true to this violation.
I do.
I'm looking at this. And it says proceed only on counts 2 and 3. We only dealt with count 2. Is that, can I take out 3?
Yes. I was just matching the prior time, Judge. That's all I was trying to do.
Agreement is you would be, your probation would be revoked. You would be found guilty of this Class A misdemeanor and sentenced to 6 months in the county jail. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
I'll show you what's marked as State's Exhibit 1. Y'all got to sign on the bottom, please.
Okay.
State's Exhibit 1 you signed, and is that correct, ma'am?
Yes, sir.
And this states that if I follow this agreement, you have no right of appeal and you're waiving all right of appeal. I'm going to do this. Do you understand?
Yes, sir.
Anything else to add?
Judge, do we need to enter anything about vacating the prior order?
I'm about to do that.
Okay.
Anything else to add?
No, sir.
All right. Then the earlier order on June 29th, 2026, which was inadvertently entered as we all, the parties in the court understood this was a state jail felony, which in fact it was attempted burglary of a building, which is a Class A misdemeanor. The defendant was indicted for a state jail felony, but pleaded guilty originally to the lesser included Class A misdemeanor. That is corrected by what the court is doing today. And now the court finds, as it withdraws all those earlier orders on June 29th, 2026, revoking her probation, this court puts her back in the position she was, where she was placed on deferred or unadjudicated probation on June 17th, 2025. That deferred or unadjudicated probation is hereby revoked on this day based upon her plea of true to allegation to admitting to using illegal drugs, a violation of condition 10 of her deferred or unadjudicated probation. That grants this first amended motion to revoke unadjudicated probation filed on June 17th, 2026. That's granted by a preponderance of the evidence or greater, and her deferred or unadjudicated probation is hereby revoked. Earlier in this case, she had pleaded guilty to this Class A misdemeanor voluntarily, knowingly, intelligently. There was sufficient evidence supporting her guilty plea to find her guilty beyond a reasonable doubt at that plea hearing. I now find you guilty beyond a reasonable doubt of this Class A misdemeanor that you had originally been placed on deferred or unadjudicated probation for, and you were hereby sentenced to 6 months in the county jail. You will be given credit for all time you have served in accordance with this case. Do you understand what's happened here, man?
Yes, sir.
Right, anything else on this? Okay. So,
Alrighty, friends, that will bring it to a close. But before we do, Lindsay, thank you for the 10 there, TCF overtime. Happy to do it. Again, apologies for those of you who are here at the very beginning. I've never seen it happen before. The stream got just a few seconds in and Restream just dumped it. And it's usually much more reliable. So got us off to a little bit of a late start, though. So happy to go a little long today. Also, from Friday, I did not get this notification until late Sunday night, late last night, because my notifications were broken for some reason, but I got it fixed. But Grandma TCF gave us $25 over at courtroomfiles.com. So thank you, Mom, for doing that. I appreciate it. That will do it for today. I hope you all enjoyed it. We'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific. The wisdom I leave you with today, as in water, face reflects face, so a man's heart reveals the man. That is from Proverbs. I encourage you to chew on that little bit of wisdom. Go have yourselves a good day. We'll see you tomorrow morning. Take care. God bless.